All right, we will call this meeting to order. I think I'm going to test that next week. It's funny, when we just sat down up here, it got a lot quieter. It's kind of neat. But first, I want to start off by saying thank you very much for everyone for being in attendance. We really do appreciate it, you coming to your capital to see how things work. And at the end of the day, you guys are the reason we're here, trying to get this right. My name is Jon Echols. I am co-chair of this committee with my other co-chair, Greg McCortney. As we discussed last week, we will be taking turns chairing the committee. All decisions are made together, but at the end of the day, when you run a meeting, only one person can run a meeting. So that's how we're doing it today. And I'm going to turn it over, Mr. Co-Chair, did you have any opening remarks?
Not really. I'd just thank you guys for coming back again and for the opportunity to ask you questions, and also just for the hard work that you've put in. We invited these groups back specifically because they have submitted drafts, whether it be 788 or drafts on what we need to do above and beyond 788. And so to look at those drafts, really, in my mind, three groups that without all three of you, 788 would not have passed. So I think we have a great representation of the people who brought us this law, and now we need to figure out how to go about implementing it and looking at your drafts. So I appreciate you being here, and I won't waste any of our valuable time.
Well, thank you for that, Mr. Co-Chair. We're going to have some housekeeping stuff talking about, at the end of this meeting, talking about the next meetings. I have a lot of interest in people that want to speak. I want you to know we're doing our very best to get everybody here. There absolutely are more people that want to speak than we have time to make it happen, and that's exciting. I want to say that for the people in the room, but also for the public, so they understand there is a great deal of interest in what we're doing. I'm going to, before we get started, I'm going to announce our presenters, and I want to start off for our members. We're doing a little bit different format than we are used to as both the House and the Senate. For lack of a better word, this is going to be a little more congressional style. We are going to give each presenter a 5-minute opening statement. If you want to take it, don't feel like you have to, but you can up to 5 minutes to say whatever it is you want. And then instead of how we did last week, where you might have a question from Senator Paxton and then from Representative Roberts, we're going to give each member up to 10 minutes, so just one person is asking questions at a time. The goal is to have a much more orderly process, and frankly to make it easier on you, the presenters. So instead of bouncing back and forth, we're going to call one member, and every member of the committee is going to be asked up to 10 minutes of questions. Members, we are after that 10 minutes of questions, because this is fact-finding. We're going to go back to our traditional system, where at the end you will have the opportunity to ask more questions. I will be serving as timekeeper. My job is not to give you a hard time at 10:05, but just be reasonable with me. And as we go through this process, and members, don't feel like you have to take the full 10 minutes. So if you have your questions prepared and you've asked all that you want to ask, there's no reason to take all 10. This is all fact-finding. The goal here is to get to the best possible process we can have that effectuates the will of the people as they have told us they want done in 788. And we think this is the most organized manner, as we've talked about, to try to eat this elephant one bite at a time, so we can kind of drill down. So for everyone that knows, I'm going to announce all the presenters, and then I'm going to give you your opportunity to give an opening statement. Presenters, part of the reason I'm doing this, so you tell me if there's someone else here talking and I forget, but for Green the Vote, we have Isaac Cavanis and Ron Durbin.
I'm Chris Moe. I'm also with Green the Vote.
You're with Green the Vote? Okay, good. Yeah, there was that one. And we have Chris Moe with Green the Vote. With Oklahomans for Health, we have Chip Paul. And with New Health Solutions, we have Bud Scott. We have no objection. I know we have no objection if you want to bring somebody else up with your organizations. Don't feel, if there's no way to do this without it feeling very formal, but that's not our goal. Our goal is informational, to have everybody to have their opportunity to to get out. And our goal is to work together to come to an agreement. So the only thing we would ask is when you're talking, the first time you talk, because we do have this live streamed, introduce yourself. So you have to the audience. I was talking on my way up here with actually several of our presenters, and one of the things we were talking about is right now, both as a legislature, frankly, as an audience, we're putting on a great foot for the citizens of the state of Oklahoma. We're showing them how we can go about doing this in a serious manner. For that, there's going to be some hard questions today, I hope, because that's the goal. There's going to be some hard answers. It helps to not have outbursts. And guys, when we had the veteran talk last week, even I started clapping. So we're human. I'm not saying that that's not going to happen. I will tell you the reason we have that is both for our questioners and for our presenters. We want everybody to feel comfortable in this, so it's not to be harsh or to stop all that, but I did want to announce that before we got started. And this audience has done an incredible job of doing that the past week, so I'm not worried about that. So with that, we are going to get right into it. And Mr. Cavanis, I'll announce you with whoever you want to do for green the vote if you'd like anyone to make an opening remark.
Ron Durbin, I'm the attorney for Green the Vote. Don't want to take up the full 5 minutes, but did want to inform everybody here. Had a very productive meeting this morning at 7:30 with Tom Bates, the interim commissioner for the Department of Health. I had expressed some concerns with the new version of regulations that came out yesterday. I believe that they're working as diligently and was extremely encouraged by their openness to receive some criticisms regarding their incorporation of some other statutes that create problems. It's my belief that they're working as expeditiously as possible to come up with reasonable regulations given the framework that they have in 788. As I expressed to Mr. Bates and I'll express to this committee, I do think they need additional guidance and authority to deal with some of these issues. Because of the enacting language in 788, it creates some conundrums for the Department of Health. That said, I am extremely encouraged by what they're trying to do. What I advocated to them, and I told them I would tell you guys, is for them to be thoughtful and perhaps have a discussion today at their meeting and take another week to really think about what it is that they're trying to do and what they're trying to enact here. I think they are in the right direction. Today, I think, quelled a lot of my concerns that they were trying to do one thing in public and something else in the back room. I didn't get that sense, and I did want to express that publicly, that we are encouraged by what they're doing and faithful that they're trying to do this in the right way. And I want to thank Mr. Bates for meeting at 7:30 this morning, which was certainly before he had to be there. With that said, we want to reserve all time for the committee to ask whatever questions they have.
Thank you, Mr. Durbin. Next, I would like to go to Mr. Chip Paul with Oklahomans for Health.
Yep. Thank you, Representative Echols. And I also brought up Chance Gilbert, who's with the newly formed Oklahoma Cannabis Trade Association. I think he's a face you guys need to kind of get used to seeing as well. So the Department of Health released a new draft yesterday, so that was interesting. Again, that draft is probably enough to begin to develop an industry under, but it's probably not enough to fully flesh out an industry, and we recognize that. We have been working with the Department of Health, and gosh, the staff over there really deserves a big pat on the back. I mean, They've gone from hundreds of pages of regulation to 20 pages of regulation, and I think they've probably heard from every single stakeholder in this state. So they've done a great job, I think, of responding to that, of trying to listen to everyone. What we produced with them last week, I thought was a very, very good set of regulations. It was about 58 pages. It looks like they've gone straight to kind of nuclear winter with the Attorney General's, letter, and that's fine. And it definitely, what they have done is enough to build an industry under, but it certainly leaves a lot of room for work, I would say, to be done the next legislative session, absolutely. And I think author recognizes that, okay? One thing that I would, and that's really about all I have, but I would like to extend an invitation really to the committee here, and I think that this would be a very valuable thing. And again, how this gets paid for, I don't know, but I would like to extend this invitation to this committee to either go to Colorado or Nevada or Arizona and actually go on a tour with industry experts, and we'll set this up and make it all happen, but actually talk to industry experts, actually talk to regulators in other states. I think that would be very valuable, and talk to activists like us, right? And see how it kind of works in other states and demystify this a little bit. Again, we don't know how this works, most of us, right? How many people have been in the industry in Colorado or Arizona or Nevada? So I think we can, and ideally we do this in November, and we do this around a conference called MJ BizCon, which is about the biggest conference in Las Vegas. And so that would be a really good way to expose you guys to really a lot of what this is about as an industry, medical and adult use both. And it looks like we may have, adult use on the, at least on the ballot sometime. So I think it's going to be just good education. But I would like to extend that to y'all, and I will, coordinate that offer, I guess, between you two, if that works. So thank you.
Well, thank you, Mr. Paul, and thank you for the offer, and thank you for being here. I want to recognize for an opening statement, Mr. Bud Scott with New Health Solutions.
And thank you, Representative Echols, and thank you guys, other presenters, for being here today. Thank you, senators, representatives, for having us to speak on this critical issue. We've got several of our members here in the audience today as well. I won't bring them up here, and then my political director, Jed Green, as well. Our staff is at our offices today. So some changes between last week and this week. The proposal that we had submitted previously, we had posted this for public comment and accepted over, I think 175 public comments, something like that's hard to keep track, and integrated those public comments into this document to reflect changes that some of the members of the public may have had, and then also reflected some of the questions that you had at the last week's meeting. So we've done our best to try to modify this document, streamline it down. I joked about it yesterday. It's like we put it through the Rocky III montage training so it could lose a little bit of weight, and took about 70 pages off of it. So I'm happy to answer any questions here. I'm going to echo Mr. Durbin's sentiment that the Health Department, Tom Bates and his staff have really worked their tails off on this deal under some pretty pressing circumstances and some pressing timelines as well. And hopefully we can find some ways here at this committee meeting to identify manners that we can advance this issue and implement 788 in a timely, responsible manner.
Thank you for that, and thank you for that statement. Members, at this time, we're going to move into the questioning phase. There's going to be absolutely a very simple method to my madness. I'm going to go right to left, as who is sitting in front of me, knowing that it's bicameral and bipartisan, and there's no other way to do it without getting me in trouble. So we're going to do it in that manner. Members, I want you to ask hard questions, keep those questions respectful. Under the rules I sent out, I had mentioned that the co-chairs were going to go first. I actually think, under my prerogative, I'm going to go last. If you would like to do the same, Mr. Chairman, or if else, I'll take you first.
I'll go first.
All right, well then, at this time, I'm going to recognize my co-chairman, Senator Greg McCortney, for purposes of questioning.
Thank you very much, and yes, I have something else I'm going to have to sneak out early, so I don't want to go last because I know a bunch of long-winded people in the room, and I may leave before y'all are done. So, so just to get started, I've got some, I think, simple questions, and then maybe they'll get more complex. But my first question is somewhat of a yes or no question. From looking at your drafts and reviewing what you said in last week's meeting, can you tell me where your groups, or where you personally, however you want to answer, stands on the question of whether or not a physician in Oklahoma should also be allowed to own a cultivation facility or be able to own a medical marijuana dispensary? So I'll just throw that question out to begin with.
I'll answer that from my perspective, but again, would a physician, be allowed to own a pharmacy if he was an opiate patient? I mean, I just pose that back to you in that way. So with all respect, this is a medicine. If a physician is a patient and needs that medicine, that shouldn't preclude him from doing business in the industry by any means. And I understand the intent, in regulating basically, keeping a physician from having a business interest. So I think that is where we draw the line, right? But a physician who's a patient shouldn't be precluded, from participating in the industry. It's literally like saying, I'm a Benadryl,
And specifically, I'm asking, can a doctor own a marijuana dispensary? Not can a doctor have a prescription? Can they write the prescription and sell the marijuana both?
In my opinion and under intent, I would say that they basically can't feed their own business. I think that's where we would, feel comfortable drawing the line. So,
Thank you.
Yeah.
Other groups?
Isaac Havenis with Green the Vote. I would say that our opinion on this is that we understand the ethical boundary there that a recommending doctor owning an interest in a business is some pretty hairy ethical lines there, and we would not be opposed to that restriction being in there. It seems like a reasonable restriction to us, and we wouldn't fight you on that. I do understand what 788 says, and and I'm not trying to go against what 788 says, but there has to be some compromise in some of these areas, and I would say that that's one that we would all probably be likely willing to accept.
If I could add one thing, I would make the analogy to Stark. There's Stark regulations federally related to what doctors can and can't own and participate in. I think that some reasonable, similar Stark-type regulations related to this would be an appropriate thing. I think that, I don't think there's going to be anybody up here that's going to disagree with that, but I could be wrong.
Senator, I'll echo those sentiments that Mr. Durbin just had, and then also, we've reached out to several medical organizations to try to find some guidance on this issue. To this point, no one has provided any concrete exclusions for physicians from owning any ownership in a marijuana-related business. So that's the answer we'll give you.
Okay. So my second question is that, again, personally, your group, however you want to speak on this, should a medical marijuana dispensary be allowed to open in a residential neighborhood inside a city in the state of Oklahoma?
Okay, so I'll speak to that. Again, what we put in the law was 1,000 feet from the entrance of a school, all right? But how you open a marijuana dispensary will fall back to zoning laws, right? So you can't open a marijuana dispensary in the middle of a neighborhood. I mean, that it won't be zoned that way, right? You could open a marijuana dispensary in a strip center, provided that landlord gave you written permission that you could be there. And I think that was our intent, was that you certainly could do that. But no one wants to, I don't want a dispensary in the middle of my neighborhood either, right? So that the intent was not that, absolutely.
I'm sorry, go ahead. I want to let everybody answer the question. So.
Yeah.
Whoever wants to go next.
I'd say the same thing, Senator, that we're looking at the implementation of zoning laws on a city-by-city basis. They'll have the ultimate determination as a local community as to what kind of businesses they would like to see in their neighborhoods, for example. But one of the issues I would say is that you see pharmacies, especially out east in the older communities, where there's pharmacies within neighborhoods with their little kind of town squares per those districts. And I think we just have to be careful not to continue to treat the potential cannabis business as a criminal enterprise versus something like a pharmacy.
I would agree with Mr. Scott. My only concern with restricting wouldn't be restricting one from going into a neighborhood, but maybe if it was restricted too many feet away from a neighborhood, that could regulate things outside of metro areas. So That would be my only concern, is that there wasn't any over-stringent distances that needed to be covered to get away from a residential neighborhood.
Okay. Thank you.
Can I just have a follow-up?
Sure.
Okay. It just, in that, the way that the draft was written was schools and churches and playgrounds. It's, draw those circles sometimes.
When you say the draft, you mean the Department of Health?
Yeah, Department of Health. Yeah, and so when you begin to draw, when you begin to draw those circles, that literally cuts out almost any commercial, available real estate in Oklahoma City or Tulsa. So that's where and I think to Isaac's point, we need to be careful what we do there. But we obviously, no one wants dispensaries in the middle of neighborhoods unless it's the situation like Bud talked about.
Okay. And you talked about, Mr. Paul specifically, you talked about the intent of 788 as the one of the authors of 788. The intent and the reality of 788 may not necessarily be the same. Is everyone sure that you can't open a dispensary in a neighborhood with the law the way it was voted on by the people of Oklahoma?
So again, and I think this is it's a good question because it almost goes back to the same employment law questions. Because we voted this in as a law, and again, you guys are lawmakers, so you are way more experts here than we are, but my understanding is this: we can say you can't unduly zone, this business basically out of things, and that's what we tried to, specify in 788. But by no means can we override, a city's ability to say, in this region, it's a zoned, residential, and you can't have a business there. We can't override that, just like we couldn't override, federal or state employment laws other than to reference them, right? So, yeah.
Senator, it's our position with regards to the way 788 is drafted, and we certainly wouldn't have any objection to reasonable restrictions on what kind of zoning in which a dispensary can operate. I don't think there's anything in 788 that precludes that. As Chip said, what 788 contains is provisions that say you can't unnecessarily zone or change zoning for purposes of restricting a business from going into those places. I think under existing commercial, residential, and industrial zoning laws, a commercial business can't open in a residential area. That wouldn't be a change of anything which would be prohibited by 788. That's already in place. It would be changing somewhere to some other zoning for purposes of excluding. That would be the problem. But, creating any kind of regulation or statutory scheme that kept this out of residential neighborhoods with reasonable restrictions is not going to have any objection from Green the Vote, for sure.
Yeah, nor us. So.
Mr. Scott, do you want to respond?
No, Senator, but we've explained this. We have a proposal or a section within our proposal that identifies how you interact with local licensing authorities, primarily cities and city governments. There's some guiding principles contained within the International Building Code and the International Fire Code, which set forth zoning principles as well for cannabis-related businesses. And we highly encourage both cities and the state to look at adopting some of those provisions because it's already been spelled out and it's something where we don't have to reinvent the wheel.
I could continue to go with examples, but I picked those two questions specifically because I was pretty sure I knew what your answer might be. And so before I run out of time, my question is, and you said in your openings and you said last week, 788, or not all of you, but some of you have said 788 is a good start. In February, May, whenever, during regular session, let's wait till the spring. Let's implement what we have. Let's wait till the spring and fix whatever problems pop up. And so my concern with the two things that we just discussed is if we move forward with 788 here in a month's time almost, if we issue a license to a doctor who owns a dispensary, I don't think we can ever take that back. If we have a city that approves if the city of Ada approves my next door neighbor to start selling marijuana out of their garage because their reading of 788 says that they can't stop them, we can't ever take that back. I think that we're on a crash course to hand out license very soon that I think every one of us agrees some of those people shouldn't be getting those licenses. And so I want to ask the question that I asked again last week is, why are we in such a hurry knowing that we're about to mess this up? Anyone want to respond to that?
I have one response, because too many people are suffering, and I realize that doesn't compute to words on this paper. But in this instance, I fall back on that old saying, better 10 men go free than one guilty man go to jail. I would rather run into those problems than have people continue to suffer another day. That's my answer.
And I would go to the same place. We've been fighting for this for a very long time. There are people in this state that truly are suffering. We are talking about this as a business and how to regulate it and how to protect people and how to protect people in Oklahoma. But we also, in that protection, we also need to consider those patients. That's very important. Okay, so to your point, though, in our draft that we went through with the Department of Health, that we left saying, we're good. You know, if we adopted this as is, butterflies and rainbows from Oklahomans for Health, we'd be ultimately happy with that. In the draft that we went through with them on Friday, last Thursday, we have protections against the very thing that you're talking about with physicians. And it was in there. It's not in the thing that they produced yesterday, but it was in the red line that we discussed Thursday with them. So again, we're supporting that idea. What I'm telling you, we're absolutely supportive of that regulation. It's in their stuff. They just need to dust it off and then bring it back up. And so they went, you know, nuclear winter and went right to the Attorney General's, you know, language. But what we all agreed with them to, really, was a pretty good set of regulations. So.
Senator, with all due respect, there's something in logic and rhetoric. It's really called a fallacy. It's called a straw man. I think what the presupposition that you were proposing there is a straw man. I don't think 788 authorizes somebody to open up a shop in a residential area in their garage. I think that the provisions in 788 are such that they're not allowed to do that in a residential area because of existing law. You've got to remember that 788 has to work with and in conjunction with existing law. There are existing zoning regulations in place on the books that you must work 788 with. And a commercial operation in a residential area is already prohibited by the commercial zoning laws in place. So I don't think that that idea is an area that's going to be of concern. Additionally, the ability to take away authority that is granted by statute doesn't raise, I think, the due process concerns that you've addressed. There's nothing that, if you follow the process of amending state statutes, that's going to create some kind of equal protection or due process clause concerns for those who have already been granted a license. Should this legislative body look at grandfathering in certain businesses into the legislation that might ultimately be passed? Absolutely, because they have an economic interest in it, and it's the right thing to do. But it doesn't create the due process concerns that I think your question supposes.
Go ahead, Mr. Scott.
Senator, thank you for the question. A couple of things. One is we've stated all along through the course of the campaign, election eve, and since, that there is a need for additional clarification through supplemental statute. I think these are just some of the reasons why we need to have these issues addressed. Typically in any kind of licensing process, whether we're talking about a hospice center, whether we're talking about a medical bed supply company, whether we're talking about what I'm familiar with extensively here in Oklahoma is the liquor industry, that you're not issued a license to operate that business until you've had your certificate of compliance issued, till you've had your inspections, till you've complied with code at the local level. And we just believe that we need to have these processes set forth to make sure that this industry is treated like any other industry. And the goal here is for normalization of the cannabis industry in Oklahoma. So I think we'd like to be able to be on par with that. I think that's going to require immediate addressing of some of these issues through statute. However, whatever we can do to help build upon what the health department is already trying to implement, so patient access is not delayed any further than it already has been.
Thank you very much. I'm sure my time is up, so.
It is, and if you're also keeping time at home, if you're the co-chair of the committee, you get to go long. So I have had, and I bet he'll give me the same courtesy, I have had several, so the good news is there are lots of people listening. The bad news is there are lots of people listening and we're not doing a great job for them. So I know it sounds so weird, but say your name before you start speaking, if you don't mind, and it takes a while to get a hold of. I've had members of the media and just regular activists text me because they just want to know who's talking. And I know it feels weird. Believe me, I'm used to it. That's why when we stream stuff, we always announce who's talking. So as best you can, I'll try not to interrupt you, but I might, and talk into the mic, because there are a lot of people that care about what we're talking about today. So you're all doing a great job answering questions, but I've got a lot of texts asking me to point that out. Thank you, Mr. Co-Chair. Senator Paxton, you are recognized for questions.
Thank you, Mr. Chairman. I'm going to just kind of start off kind of picking up where Senator McCortney left off. And you used the phrase several times, zoning laws. They are not zoning laws, they're zoning ordinances because they're passed by a city. The problem is, and Senator McCortney and myself are both former mayors of our communities, and the concern we have is that whenever there's an ordinance written or a state law written where there's a little hole in it somewhere, somebody tries to crawl through it. And that's why we're concerned in the neighborhoods. And so that's where the issue is coming from, is we've dealt with this before. And when you read the state question, there actually is gray areas, is what can a city actually do. I think we talked last week, and I totally agree. A city shouldn't be able, according to your state question, I agree, you can't just say no dispensaries in our city limits. But it should be where a Walgreens could go, a dispensary could go. I think that's where we're at, but the concern is it is not clear. There is a little bit of gray area as to what a city can and can't do, and that's where that address comes from. I completely agree with the senator that that's where the concern comes from, because we've dealt with it. Someone will push that envelope, I can assure you, in some community in this town, and that's where that comes from. Because the state question seems to me, but what I've read in it, would get in front of those ordinances and would take precedent over those ordinances. So, just want you to know where that question's coming from. In the same tone about zoning, Mr. Paul, you had said, kind of where a city would zone for commercial businesses, where this should be able to go. Then you went on to say, if a landlord gives permission.
Yeah.
Going back to private property rights, which I kind of hit briefly on last week, would the permission of a landlord, for example, if I own that strip mall, but I just didn't want dispensaries in my strip mall on my property, do I have a right as a landlord to say, I don't want that here?
Yes, absolutely, absolutely. So I would, that it was never the intent, and again, I don't think we could even do this, under the law. I don't think we could override, a landlord's intent for his property, right? So it's absolutely, we agree that a landlord should have the ability to restrict a tenant from being a dispensary or grow or process. So,
Anybody else?
Green the Vote would agree with that sentiment. A landlord should be able to restrict access to their property. They have property rights as owners, and they can do with their property as they please, and not licensing or not leasing to a dispensary or whatever would be within their prerogative.
Okay, thank you. You give that?
Senator, we would agree with that sentiment, as well as private property owners being able to restrict who can actually consume by smoke this product on their property. There was a lot of discussion of this during the campaign, and Bud Scott, New Health Solutions. Sorry, I'm trying to remember their Representative Echols. But yeah, there was a lot of discussion of this during the campaign about whether businesses or private property owners could restrict the ability to smoke on their properties. We believe they should be able to.
Okay, thank you. I'm going to jump into a little bit kind of the area, like I said, I kind of keep hitting the same areas, kind of public safety, workplace safety. And maybe this is a better question when we bring some law enforcement in here to ask them, but you all can probably help me out with it because I haven't got a real clear answer. If a police officer observes somebody driving in a way they feel they could be impaired, if they pull them over, if it's alcohol, it's a very scientific test to find out whether they are intoxicated or not. Whether it be marijuana or opioids or any other type of a drug, what is the test that they would use to properly detect if they are impaired?
As 788's Isaac Havanus with Green the Vote, as 788 says, I don't think that it spells it out. I could give you a suggestion of what I think would be reasonable at this moment in time where we are at with all of the testing, trying to figure out what levels could make someone impaired. The problem is that everybody has a different level that makes them impaired, and the amount of time that somebody has that in their system will change that level of impairment. So my suggestion would be is that if someone is being charged with a DUI for cannabis, that officer that's arresting them do a field sobriety test in front of a video camera to show to a judge or a jury the impairment that this person is being accused of.
Chip Paul with Oklahomans for Health. And that's a really good question. You know, a lot of states are struggling with that very issue. So how does law enforcement test for, you know, cannabis impairment? And there's really not a good issue, I mean, not a good answer yet. It's a chance to lead, I'd say. So there are tests, there are blood tests that potentially could work. There are, there's things in research that definitely are being talked about that could be accurate and proper tests for impairment, so.
And Senator, but actually, Bud Scott, New Health Solutions, Oklahoma, I would actually echo the sentiment of Green the Vote here. They have some language that's really strong as far as using a field sobriety test to determine whether someone's impairment is beyond the level, through the acceptable level. There's certain major issues right now with determining whether it's in your bloodstream, whether it's urinalysis. There's some technology that's been developed where they can actually use kind of a breathalyzer, but that's only effective if you've been consuming the product by smoke or you've just recently eaten the product for an edible form. So as technology evolves, I think we'll be able to start addressing this in a more complete manner.
Okay, kind of moving this off the roadside and let's move it into the workplace. On the way in this morning, I was invited to stop by a local business. They employ about 50 people in the oil field service industry. And this, I'm just going to pose a question that was posed to me at this question and answer deal that I had this morning. And it was from one of the owners of the business. And they're a subcontracting oil field service company that goes along to the rigs and does service work there. If the rig operator, are they allowed under your version of this, the rig operators can say, you know, nobody that has THC in their system, nobody that's taking medical marijuana or opioids or anything else can be on this site. Mm-hmm. And that would move over into, and that's kind of what this business owner said, we're going to follow whatever the people that's hiring us say. Is everybody okay with doing that? Because if I understand THC is going to stay in their system for 3 weeks, plus or minus, and so, but I know in some places, if you have it in your system and they test for that, you're not allowed to do certain jobs on that. Is coming to workplace safety and rights of employers, is there any part of this that we're going to have trouble with as far as finding a common ground?
I don't, and Chip Paul, Comments for Health, I don't think so. And again, it was never the intent, again, to have, to restrict employers for being able to write their own laws or have their own policies. The reason that we specified certain things was this, and let's say, to your point, to your example, it's an oil field company, and let's say they have a policy that, you know, if you're being treated for back pain or something, you know, you are able to take opiates in the evening, right? And let's say they have a random drug testing policy. Right, so someone shows up and tests positive for opiates, and you know, you ask them for their prescription and who's your doctor and are you just taking them at night, and that person's okay, right? Under your policies that you wrote for your company. All we said in the law and what we really meant to specify is that if you have those policies in your company, you would have to also extend those to a medical marijuana patient, right? So again, if someone is a medical marijuana patient and you have a policy where it's okay if they use their medicine in the evening, not at work, not be impaired on the job, all of that, that you would grant them the same rights and privilege you would a opiate user or a Benadryl user or, you know, whatever else. But absolutely, and in no way, shape, or form I'm an employer, I want to retain my rights, to hire and fire employees under my policies and my practices. So I feel like we don't and we can't really step on those policies, so.
Okay, thank you.
Yeah.
Ronald Durbin, Green the Vote. We are a workplace state. People have the right to choose who they work for. The employer has the right to choose who they're going to employ within the bounds of reason. And an employer should be allowed to set policies for their particular business that match what it is that they're doing. What I would suggest here is to not over-regulate that area and allow employers to make decisions on what they need to do. Certainly, hospitals employing doctors might have a different standard than a restaurant might have for somebody serving and flipping burgers. Let them, as a business, decide what it is that they need. I don't think that anything in 788 restricts that at all, and we would encourage them to be able to have that freedom to employ people that they want to employ, whether they're on it or not.
Let me real quick, because I kind of got the 1 minute left deal. In Colorado recently, there was a workplace accident of a chairlift operator that resulted in the death of that, it was actually a chairlift mechanic, technician or something, resulted in his death, a workplace accident. They found during the autopsy he had THC in his system, which was against workplace policy. The workers' comp laws in Colorado resulted in, because he had THC in his system, his wife was paid half of the death benefit of a normal workplace accident. To me, that seems a little egregious. Just real briefly, because we're about out of time, could you all address that? If that's something that as far as like our workers' comp laws go, should we be looking at how it addresses things like this?
Ron Durbin, Green the Vote. I don't think there's any restrictions currently in our work comp laws, the new versions out a few years ago, that would reduce that payment at all. I don't think there's anything existing in our statutory scheme related to work comp that would do that. So as far as whether there's a need to address it, I mean, I certainly think you could address it to say it's not excluded or it's not going to reduce your benefits, but it doesn't now. There's nothing in the scheme now that would reduce it for any drug use, for that matter. An accident on an employer's property while somebody's engaging in work is a work comp covered claim, period. And nothing as in 788 changes that, and I don't think there's any need to address it unless you really want to.
Yeah.
Senator Bud Scott, New Health Solutions, Oklahoma, real quick. We have an entire section on this, section 12S, within our proposal that addresses some of the potential employer issues. This is one of the hottest topics in cannabis law nationally. The employer relations issues are continuously evolving. We're seeing new decisions handed down almost monthly from state to state. So there's only so much we're actually going to be able to do through statute to address this, because it's a constantly evolving subject.
Thank you for that. Thank you, Senator Paxton. Senator Brooks, you are recognized for questions.
Thank you, Mr. Chairman. And so, more than anything, I had a chance to be able to review all the materials yesterday evening, and so I don't know if I have kind of as much of a consistent kind of theme, so much as different things that I noticed that I had questions about. And so the first one is that I noticed that I think for people who choose to grow at home, and then also caregivers, that there are potential penalties for diversion, which I guess diversion would mean that if you're not using it personally the way that it was intended. And so I was curious whether or not that would just, if that would be something where you would just lose your license, or there's potential criminal liability as well.
So Chip Paul, Oklahomans for Health. The way the law is written, again, one of the things that we wanted to prevent, honestly, is situations like in Colorado. So when Colorado first rolled out their medical marijuana program, you had a caregiver program, but you had caregivers growing way in excess of what they should have been for patients, and then selling, that excess to dispensaries. So they were basically acting like growers, but not with growers' licenses. So we wanted to really close that hole, and as loose as 788 appears, we did do some things that are really good. And so that ecosystem is really tight, meaning that a dispensary can only buy in certain places, a grower can only sell in certain places, a processor can only buy and sell in certain places, and a caregiver can only do certain things. So if that caregiver were diverting marijuana and selling it to a dispensary, that's a felony. I mean, that falls to the same marijuana laws that we have now. That's outside of 788 and outside of any medical program. Similarly, if anybody's diverting, marijuana out of this program, they would be subject to the same, laws and criminality that they would be now, or without this program. So, does that, thank you.
Isaac Cavanagh, Green the Vote. The question you bring up points out a problem that probably does need to be dealt with, and we've been talking about. We just have not figured out exactly a way to make it happen, which is to give a patient or a caregiver an option to get rid of his excess product. Yeah, Chris, you want to talk about that for a minute?
Yeah, Chris Moe with Green the Vote. If we could, I know a lot of people are concerned about the home grower growing extra, and we've all wrestled over whether they end up with a few too many in flour or a few too many in veg, and how that all works out. One thing I would like you guys to seriously consider is we need a legal way for the home grower to get rid of any extra they grow. The reason for that is if a home grower grows a large plant, he's clearly going to end up with more than what is his legal amount, even after he makes everything out of it. I mean, it's possible to grow them that large. So what does he do with the rest of that? Well, we don't want that to end up on the black market, but we don't want people to be put in handcuffs. So I'd like you guys to consider a few options. One would be to find some legal way for them to sell it to an organization at, say, a discount, so they're not in the business, so they only get what they've invested in it, not any profit. And where I'd like that to end up eventually is in a charity, okay? Plain and simple, I want hemp for hospice. I want the home grower that grows extra to be able to recoup his cost and to give it to charity. And I want us to find a way to write whatever rules are necessary to make it possible for us to develop a charity that can take all that and give it to hospice patients. That's what I think needs to happen to it. Now, as far as whether law enforcement gets involved or what these fines are, what we're trying to avoid here is the continuation of people being jailed for cannabis, people's lives being ruined. So there has to be some way, a legal way, to get rid of that. And I can assure you, everybody will follow that. I mean, it's amazing. I've mentioned this in online, and it's amazing the response. Everybody in Oklahoma wants this. So I would just ask that you guys work with me and help me find some way to make that legal. Thank you.
And Senator Butts got New Health Solutions, Oklahoma. Thank you for the question. I think the original question is, how does State Question 788 address this? And this is just kind of another issue where 788 needs further fleshing out, because it authorizes the possession of 6 plants, 6 mature plants, 6 immature plants, but there is no kind of protocol for how that is potentially enforced. Now, what we've proposed, we completely agree with Green the Vote on this position that this is something that should be moving away from criminalization, and we propose a civil penalty based upon the amount of potential plants that if you violate the terms of your possession limits, that between 1 and 15 plants over the limit would be a $250 fine, no criminal penalty, and then beyond that would be a $2,500 fine and loss of licensure.
Okay. All right, to follow up, having to do with caretakers, and so as I understand it, they would possess a copy of the license of each person that they serve as a caretaker. And so that would mean that, I guess, they would increase by each person that they have a license, that they've agreed to be a caretaker, that's the number of plants that they're able to increase by. Is that right?
Senator, yes, that's typically how this works in other states.
Okay, and so for caretakers, is there any potential limit on the number of people that they can serve as a caretaker to?
Can I address that? So,
Sure.
Chip Paul, Oklahoman for Health. That absolutely, in our draft, and many of us were in this draft session with the Oklahoma State Department of Health, but in that draft that we produced, we discussed this, actually, and we discussed 3 to 5 as probably a pretty good limit. that is what we expected actually to be, in the kind of the results and output of that meeting that we had with them last Thursday. But we discussed 3 to 5 as a cogent limit. I mean, no one wants caregivers growing for 100 patients, right? So wasn't the intent and not what we want. So 3 to 5 is probably adequate.
Okay.
Would you agree?
Yes.
Yeah.
And so I think my question's maybe a little bit more succinct, and so the next one, I think, is that as it stands, each licensee would, the maximum amount that they would be able to possess without any kind of special condition or anything else is about half a pound, is that right? 8 ounces?
Chris Moe, Green the Vote, yes. In flour, it would be 8 ounces.
Okay, and so for the caretaker, it would expand by the number of people whose
Yes.
licenses that they hold?
Yes, it would.
Okay. And then the next thing is, would a caretaker have, as far as being able to carry it, would they still be limited to the 3 ounces that everybody else is limited to as far as they were going to deliver it?
No, Chip Paul, carrying it is 1.5.
Oh, I'm sorry.
Okay, and I kind of understand where you're going. I mean, is there a cogent, do we want some caregiver having, hundreds of pounds or something? No, we don't. So I think, how do we gate that? How do we limit that? The thing that we talked about with the Department of Health was just basically limiting, the amount of patients that a caregiver could care for. And that being 3 to 5 is what we specifically discussed and asked them to put in their regulations.
Okay.
And when looking at the caregiver portion of 788, it specifically says that a caregiver can only caregive for someone who is homebound.
Yeah.
That's going to restrict the caregiver portion of the program much more than I'm used to seeing in any other state. So there's an imagination that of people thinking that these caregivers are going to be small businesses, but again, whenever you have that clearly in 788 that the patient has to be homebound, that is going to reduce the amount of patients that are looking for a caregiver by an enormous amount. And so, what Chip is saying, to have 3 to 5 patients per caregiver, that seems realistic.
Okay.
And Senator Butt's got New Health Solutions, just to echo on those sentiments. One of the things I disagree is that the Health Department does not have the authority to limit what those caretaker restrictions are or to place the numbers on that. They're not provided the statutory enabling language. This is why this is just one more thing we need to address through statute.
Okay. My last question about caretakers is, are they allowed, or is this set up in such a way that they would charge fees to their patients to be able to grow and to be able to cultivate on their behalf, or how would that work?
Chris Moe, Green the Vote, and our position on that is that should be an arrangement made between the patient and the caregiver. We don't feel that's really our place to say.
Yeah, and I would just, Chip Paul, Oklahoman for Health, I would just add to that, again, I think people are, we wanted to give, under the law, we wanted to give people the right and ability to grow their own medicine. That was the most important thing. A lot of people don't know how to grow their own medicine, right? They're willing to pay, actually, a caregiver, to do that. So is that a potential business? Probably. But the intent there really is to, if someone is homebound, to be able to grow their own medicine, and that's the intent. Whether a business sort of springs up in the holes there or not, that's free enterprise. But the intent is not to have caregivers take advantage of patients by any means, so, yeah.
Okay. And so I think this is my last question, and like I said, it's off on kind of like a tangent, but I think it's important to consider. And so I know that there are restrictions as far as Department of Human Services being able to take children out of a home where marijuana is present if it's been duly prescribed. My question is the next step. If it is determined that endangerment has happened, a child has been taken out of the home, will DHS be able to require drug tests, and would they be able to require abstinence before those parents could get their kids back?
So I'll take that one first, if I might, but Chip Paul, Oklahoman for Health. So again, this is another thing that we talked about with the Department of Health last Thursday. We had a great 3-hour meeting with them But we talked very specifically about, there was language in that draft that said, you know, you may not smoke medical marijuana in front of a minor. That's language that's kind of dangerous for the very reasons that you say. And again, we asked that that language be struck because it wasn't specific enough. We get the intent. Everybody gets the intent, right? No one here wants crazy, wild marijuana smoking everywhere, right? This is a medical program. We're looking at this as a medicine, right? So that's a very important aspect. But should you have your kids taken away because you medicate in front of them? You know, I take Benadryl, you know, in front of my kids. I mean, should I have my kids taken away for that? So again, that's the kind of rationale, I guess, that we sort of approach this with, if that makes sense.
Ron Durbin, Green the Vote. You know, I think to address sort of the premise of your question, if somebody is abusing the system and doing something that endangers the welfare of a child, and DHS brings a judicial action, the court is then vested by law with certain powers to institute whatever kind of restrictions and guidance and corrective actions that it wants. And there's nothing in 788, nor do I think there's anything that you guys could do that would restrict a court's ability, once the case is in front of them and they have jurisdiction, to impose whatever kind of provisions they deem necessary to create a safe environment for the child. So I don't think there's any concern about usurping a court's authority to do that. We've got a lot of great courts that deal with those issues, and if a judge was concerned that somebody was abusing the medical program, I'm not aware of anything that would restrict their ability inside the limits of that case to act with their jurisdictional authority.
Senator Bud Scott, New Health Solutions. I would echo the sentiment from Mr. Durbin of Green the Vote. This is something that's left up to both the courts in these specific manners and then to the legislature yourselves. I do want to reemphasize that the health department has no jurisdiction or authority on issues such as this.
And if I could add one thing, Ron Durbin, Green the Vote, to agree with Mr. Scott, he's agreed with me, I'll agree with him on this. There is a lot of enabling language that is not in 788 related to what the Department of Health can and cannot do. And there needs to be some action taken to where this could be moved over to a regulatory framework as opposed to a statutory scheme. You know, we need to allow a regulatory agency to be able to regulate an industry because, fortunately, they move faster than you guys do. And we need to give them the authority to regulate the areas that need to be regulated. A lot of these issues that I think the entire committee is addressing, the questions that we're getting here today, are probably more appropriate for a regulatory agency to deal with because they can pivot and move as is necessary. So what I would encourage the legislature to do in regards to this question and any other ones is give a regulatory agency the authority to work with groups and work inside the statutory scheme to come up with regulations that make sense. Don't over-regulate for the sake of over-regulation, but as things develop, be able to pivot, move, and adapt of what needs to be done and addressed in that framework as opposed to this.
Thank you, Senator, and thank you for your answers. Mr. Paul, and I understand this because I had a problem. Speak into the mic a little more. Okay. When you talk. No, I get it. It feels weird, but pull it up there because apparently there are people that are hanging on every word, and every time you guys don't speak into the mic, I get about 10 texts. So I'm trying not to take up anybody's time on that. But so if I give any of you one of these, that means pull it close. They're trying to listen. All right. We, at this time, and I wasn't doing it. So at this time, I would like to recognize Representative Roberts for his 10 minutes. And by the way, nobody feel like they have to take 10 minutes. I'm being very lenient on the 10 minutes.
Thank you, Mr. Chair. And I promise I will not take 10 minutes. I love the process we're doing here. A lot of the questions that I had wrote down have been answered here. I do agree 100% with the regulatory agency. I think that we do need to come up with something like that so we can actually move quicker with rules and stuff. The hole that I want to go down is the revenue and the funding here. We've got 7% tax, on the gross amount here. But you've tied the legislature's hands with the off-the-top funding, sending it straight to the health department, and then I think it's education here. over the last couple of years, we've had a lot of conversations over doing away with this off-the-top funding, giving the legislator more control over the funds so we can move it to education, transportation, our core services, instead of sending out to all these little entities. Would you guys be amenable to removing that requirement that it goes straight off the top, so that way we can actually have control over the funds that come in?
Yeah, so Chip Paul, Oklahomans for Health. So I think we would agree with the regulatory agency, and if you look at, and that's why I think it's so important really that you guys we do figure out a way to at least get some of you up to talk to industry, to understand how this works in other states, to understand how some states have really screwed things up, and they'll talk about it, right? We have a chance really to do things right here, and we're honestly, we're kind of approaching this in a really, really good way, and it's a very open discussion. Thankfully, we don't have a big driver. We don't have a big business or, big money driver here that has a big agenda. I mean, we certainly have some agendas around, but we don't have that here. I mean, it's a we the people thing, right? So that's kind of a really unique opportunity to get this right. But I would agree, I would 100% agree that the industry, I think in the future, would be better served dealing with a regulatory agency. We probably didn't quite get that right, when we wrote this. We could have worded things better, no question, in that particular piece. On the funding piece, I think, if we did transfer power to a regulatory agency, we'd let that go to that regulatory agency. And again, we need to see how this goes, right? If, everybody, in sort of the industry and things like that are working on business plans right now. So, and this is a very interesting, I think, discussion about what is the market cap here? Because again, that leads to 7%, and that leads to funding to the agency. And I can go anywhere, I can defend anything from $40 million to probably $300 million as a potential, yearly revenue here. So, 40 million is 2.8 million to run, whatever we do here. That's probably not enough. It's probably close, but that's probably not enough. 300 million is way too much. So I think that regulatory agency, though, should have the power probably to amend that.
Ron Durbin, Green the Vote. To provide a simple answer, should the legislature be able to dictate where the funds go? As far as Green the Vote's concerned, no. Our schools should be palaces. All of the money that could come in from this should go to schools, and it should go to mental health, education, and rehabilitation. We don't believe in our proposal that we provided lays out that all funds should not be able to be diverted. There shouldn't be accounting maneuvers that can be utilized to cover gaps in other departments or divisions. Our schools should be palaces. All of the money should stay where it's intended, and quite honestly, the people don't trust this legislature or any legislature right now, and the funds should stay where they are indicated to be so that people get the benefit that they expected when they got out there and voted for 788. So no, I don't think that there should be any flexibility or ability for this governing body to dictate where those funds go other than the specific areas that the people voted for.
And Representative Roberts, Bud Scott, New Health Solutions, I agree a little more mildly with that sentiment. It's what the people voted on, and State Question 788 was where the funding would be directed to. I do think we're going to run into an issue of whether this funding will be adequate to actually move beyond just paying for the cost of the regulatory agency. So,
yeah. Right, and that's what, and I agree 100% with the schools there. But what I'm looking at is we've got 75-25, but we have nothing going to the DPS side of this. And I'm kind of looking at the drug dog situation, because the way I'm kind of looking at it, my county sheriffs may have to buy new drug dogs, retrain drug dogs. I'm not quite sure how that process works. But that's what I'm looking at, is we're going to have a fundamental shift in our DPS policy through the entire state. We have $0 going to that. That's what I'm kind of giving some flexibility.
And again, Chief Paul, Oklahomans for Health, and sorry, I didn't mean to cut you off there.
Oh, you're good.
Yeah, but to Mr. Durbin's point, and again, let me clarify what I said just a second ago. So commission, regulatory commission, good. Adjusting the amount of taxation, good. But where that taxation goes, that was very clear in the law. The intent was very clear, and that was exactly as we intended. So that money, whatever that money is, needs to go to fund that agency first. So whatever that regulatory is, let's fund that, and then any excess, 75% goes to schools and 25% goes to alcohol and drug rehab. And that's purposeful in case, there's problems caused here, right? So, yeah.
Ron Durbin, Green the Vote. One of the areas we would suggest that the legislature look for to cover any gaps there would be the money that it's going to save in the Department of Corrections, not incarcerating people for using marijuana. Funding certain specific programs in DPS or any other ones, we certainly don't take issue with doing that. The concern that we have, and I think that most people have, is once you start opening those doors, how many doors do you open to be able to divert the money that was intended for schools and mental health education and treatment to these other programs under the premise that it's for, the enforcement of the medical marijuana laws, when in reality it's not. So I would urge caution in that regard.
Thank you, Representative, and thank you for being the first one that didn't use all their 10 minutes. Representative, you get the Green Star Award. Representative Bush, you are recognized for your questions.
Well, thank you, and appreciate you all, and I'm trying to delve through all this information, so some of my questions may be very elementary, and I apologize. I'm just trying to understand it. So as I was reading through this particular document, which I believe came from your group, is that correct?
Yes, Representative.
So under that, we create this Oklahoma Medical Marijuana Authority Governing Board. And as I'm reading through this, there's 9 members, and then there's an executive director that will be hired, investigators, a senior director of enforcement. Is that correct?
Yes, Representative.
Okay, and then the fund, the medical marijuana fund will be set up through the application fees, penalties, fines, interest made, sales tax, et cetera. And this fund will then compensate this board? Is that how this is set up?
Yeah, the way that Representative Butts-Scott, New Health Solutions, Oklahoma, the way that our proposal works is that you have the Oklahoma Medical Marijuana Authority, which is already being established under the State Department of Health. So we wanted to build upon efforts that are already currently underway. There's already been an RFP for an executive director of the agency. So the idea would be to have this become a freestanding entity for several reasons. One of those being that coming in January, the Board of Health will no longer have rulemaking authority. So at that point, we're effectively leaving an entire industry, an entire issue up for no rulemaking processes outside of a appointed commissioner. It's a one-man show at that point. So we're proposing that this be a new commission, a new agency out on its own that would, yes, be funded initially through the health department as it currently is, and then subsequently through the tax revenue, which the Oklahoma Tax Commission is treating this as a 7% excise tax, according to them, and then they will apply an additional sales tax, state and local, to this as well, so we'll be around 15.5%. So fees on top of tax revenue would go towards funding this program.
Okay. And I guess as a follow-up, it sounds like they're going to be doing a lot, and I understand and I appreciate what we're trying to do with it because it makes sense to me. I guess my question is the sales tax and the revenue going to be enough to sustain it?
Representative, that's a good question. I think you have to look at the various agencies across the country that manage these programs. There's some that are managed in as little as $250,000 a year. There's some that are $5 million a year, and it's a pretty broad spectrum. We can provide you with a list of those agencies and what their average costs are for annual budgeting. But I would imagine that a lot of the services that typically these agencies have their own in-house staff on, we've proposed that they have the ability to contract with other agencies. So for example, the Department of Agriculture already handles inspections on greenhouses, pesticide inspections, et cetera. That could be a very efficient use of resources by having the Medical Marijuana Authority engage with the Department of Ag to handle those inspections. Same thing with local jurisdictions, with the municipalities, being able to subcontract with their inspectors to come in and actually do the inspections on these facilities.
Okay, that makes sense. And as a follow-up, I do actually have some family members that are from Colorado and actually work as lobbyists at their capital. And it's my understanding that counties in Colorado were allowed to assess their own tax on top of what was regulatory by the state. Is that something that we will look at? And they also have some counties that apparently are what we call dry counties that don't have that. Is that a model we're looking at?
So Chip Paul with Oklahoman's for, go ahead.
I was just going to respond very briefly, Representative Bud Scott, New Health Solutions, Oklahoma. Colorado's model, you had two things. So there's two parts of that question. One is the ability for a local jurisdiction to impose a tax or a fee, and the second one is the process of opt-in, opt-out. So in Colorado's propositions originally, and you still have to this day, it's a county-by-county basis. They determine by vote of the people whether they will adopt and allow for these commercial facilities to be located within their counties. When this first passed in Colorado, you had multiple counties that opted not to actually approve the presence of these businesses in their communities. After the first 2 years and seeing the revenue that was generated from these programs, most of those counties reversed course and pursued legalizing these facilities within their jurisdiction. Now, as far as the revenue side of this, they were authorized specifically through their legislative piece and through their constitutional amendment to have a local revenue piece attached to this. That was not authorized in State Question 788, so we would have to operate within the confines of current statutory authority.
Chip Paul, Oklahoman's for Health. So I think Bud did a pretty good job of explaining that, but just I would say here in Oklahoma, what we've done, 788 is a medical program, right? It's for medical patients. It's not the panacea for state funding. It's not the windfall for local governments. It's here for medical patients. That's why we did this. The thing that looks like will make the ballot either this year, 2020 or whatever, 797, the recreational program, that is what you go party sauce on as far as local revenues and state revenues. That is the moneymaker, right? So an adult use or recreational medical marijuana program is what generates a lot of funds for state government and schools and all that, depending on how they set that up and where those funds go. But a medical program is really for patients, right? So it should sustain basically the program, right? There should be enough money and we should target things to sustain the program, but it really shouldn't be, a windfall for state or local government. That wasn't the intent or the design. It's really, for patients. And as you look at these regulations, there's good and bad in what, New Health Solutions has proposed, and there's good and bad in, what Green the Vote has proposed, and there's clearly good and bad in 788 and what the Health Department has proposed. But I would hope that you sort of recognize intent, right? Because that is a very important thing. And so, what was the intent that we had in 788 as to business? What was the intent we had as to patients? As you begin to sort of, drill into this, it's easy to change intent, regulatorily. So I just think it's very important because there's, in some ways, the regulations that you're considering are diametrically, opposed, so.
Well, and I appreciate that. I wasn't looking at this as a cash cow for the state. I was just making sure that we have enough money to cover the cost.
Mm-hmm.
So that they're not coming to the legislature and we have to do funny math to try to sustain it.
Isaac Cavanis, Green the Vote. I think it's important that everybody also keep in mind the amount of revenue and boost to the economy that the jobs will create that are working within those industries. All the supporting industries, construction, with your electricians, heat and air, all of these things are going to boom around the industry and are going to create a lot of income for the state that will also be able to be used in different ways to help fill some of these gaps.
And just a real quick to Isaac's point, Chip Paul comes for health. The tax base is going to increase. Again, so if you go 40 million, that's a pretty good increase in the tax base. If you go 300 million, that's an even better increase in the tax base. So it'll float boats, but it just not directly with the intent, of what we were trying to do, so.
Okay. And I have two questions. I have 1 minute, so I'm going to make this really fast. I know to buy alcohol, it's 21, and here it says 18. I'm just wondering on that. Number one, and number two, these are loaded questions. Doctors now can prescribe like the amount of milligrams for a painkiller. Can they then write a script for the amount of THC that they can consume? That's my last two questions.
Chip Paul, Oklahoman's for Health. We would hope that physicians are that specific with their recommendations. And again, you can't prescribe it because it's a federally, Schedule I drug. But in their recommendations, we would hope they get that specific and that they understand basically what they're doing well enough to be able to do that. That's the very intent of this. That's the very intent, really, of doing away with medical conditions, is that physician needs to be educated and really properly, prescribe or recommend this. What was your second question?
The 18 versus 21.
And I think that's a very good question. And again, we're viewing this as a medicine. It's not like it's not like beer or alcohol, right? So again, to us, this is a medicine. So we have a lot of 19 and 20-year-olds that are in our community that have served our country very bravely, that have PTSD and things like that. And we just, that was the line we chose, whether that's morally correct in circles or not, but it's a medicine in our minds, so.
Anybody? Real quick, can anybody have anything different than that?
Ron Durbin, Green the Vote. I think we would agree with Chip, and I think the age distinction is because before that, you have to have a caregiver help you acquire it. There's also the requirement that you have 2 doctors sign off on it if you're 18 or under. But you have to look at this as medication, not as a pleasure-seeking device like alcohol would be, or even tobacco would be. This is medication that people with 2 doctor recommendations can get it under the age of 18 because we're treating it as medication. And so all the 18 distinction is that they no longer have to have a caregiver go get it for them. That's really the difference here.
And Representative Bud Scott, New Health Solutions, I'd say 2 things. One, on the age limit issue, 18, because it's medical. But as far as the physician recommendations, to Mr. Paul's point, this is something where I think we would like for physicians to get to that point, but it's something we shouldn't require of physicians at this point. There's a long way to go here as far as a steep education and curve to educate physicians on how these products operate.
With that, Representative West, I'm going to recognize you, and then we are going to take a break after a 10-minute break after your line of questioning. So no pressure to keep it to 10 minutes.
All right.
And with that, Representative West, you are recognized.
How is all this, the medical marijuana industry going to fall in with our current banking laws? I would assume that a business or an individual is not going to be able to use an FDI-insured bank. And so where does it go from there?
Chip Paul, Oklahoman's for Health. It doesn't, frankly. There are ways to develop banking where you could, take funds from a marijuana business. That would require state charter banks, that don't require federal insurance and things like that. There are other solutions, that the industry is looking at, but this is something that needs to be fixed, right? It really does. It needs to be fixed federally, first. But it's something that we need to consider, and as this program turns up, where will tax receipts happen, and will those tax receipts be able to be taken in cash? I think that's an important consideration, and how we need to secure that and all that. So until we have a bank really step forward in the state that says we're going to do this, we don't have a solution yet, and that's something that we're working very hard on. On the industry side, the trade organization is talking to banks, and we're looking at crypto and stuff like that, but I don't think anybody really, wants to go there. There's no really good solutions, honestly, there yet in the crypto market, so.
Okay.
Representative Buttscott, New Health Solutions, Oklahoma, just to follow up on that. The issues, we discussed this briefly during the last committee hearing on the impact of the Controlled Substances Act at the federal level and the subsequent restrictions that it places on financial institutions doing business with marijuana-related entities. So that means that access to capital is incredibly stringent. That means that actually conducting banking business is restricted. And as of right now, as of last reports, August 2017, there's over 400 financial institutions across the United States that are conducting banking business with marijuana-related businesses. We know this because there's a process in place through the Department of Treasury for filing what are suspicious activity reports and MRBs with the Department of Treasury that indicates your participation in this industry. At this point, the only banks that have been offering this in other communities are charging exorbitant fees because of the regulatory compliance costs that are associated with that.
Ron Durbin, Green the Vote. The only thing I would add to that, and I certainly agree that there are constraints and problems in this regard. Unfortunately, none of the problems can be solved by this body. Most of the problems arise out of federal law and the FDIC and the insurance requirements there. We wish there was a simple solution to this, but other states, businesses do have access to capital through private ventures and things like that aren't necessarily a traditional bank. We think that that'll be in this market. I can attest that I've been contacted by several that want to be in this market. It'll open up, but unfortunately, there's nothing you guys can do that I can see that would make it easier at this point. Maybe down the road as regulations ease federally, certainly, but as it stands right now, we're going to face the same problems that every other state does.
Okay. And Representative Roberts, Representative Bush kind of hit on the tax, the 7%. Correct me if I'm wrong, but I don't think we tax pharmaceuticals in Oklahoma. Do you foresee problems then, because we're going to be taxing medical marijuana? I mean, do you see potential lawsuits because we're going to be taxing this?
Well, Representative Wes Buttscott, New Health Solutions, Oklahoma, I think there's always potential for lawsuits, especially when we have folks that like to sue the state constantly for their profession. But yeah, I think what we're talking about with the tax commission right now, because they've stated their public opinion as being that this tax will be treated as a 7% excise tax, and on top of that would go the state and local sales tax. So there would have to be an opinion from the tax commission designating medical marijuana as a medicine, as a pharmaceutical treatment to receive that sales tax exemption has been granted to that industry.
Chip Paul, Clemens for Health. To my knowledge, no state has been challenged on that. None of the other 29 states that have a medical program, so.
Okay.
Yeah.
Anybody else? Okay. Then to kind of go back on the safety side, as far as for the consumer, what testing requirements do you think need to be in place to make sure that the chemicals and pesticides are held to the lowest levels possible?
So
Ron Durbin, Green the Vote, not the ones that were proposed by the Department of Health originally. Let's be clear on that. They tried to adopt California standards. California standards, as they do with any industry, over-regulates for the sake of over-regulating, over-test for the sake of over-testing. There needs to be reasonable testing in place to test the products for things that will be harmful to the public. They need to be reasonable, and they need to be cost-effective. The problem that any testing program can create is that the test can essentially take the product to such an extreme level of cost to get it tested that it makes the product inaccessible to the patients. And so that needs to be in place. But, I would hold it to similar standards as you would test any other product that's going to be introduced into the stream of commerce for consumption by people. You don't need to go beyond that for the sake of going beyond that. But there does need to be reasonable testing in place to ensure a safe product. Because confidence in the market and confidence in the medication is paramount. So we certainly would advocate for testing standards to be brought forth. And what I encouraged at the last meeting was additional committees or even studies done by a regulatory agency to try to come up with the least restrictive, most effective testing schedule that there can be.
Chip Paul, Oklahoma's for Health. You know, in our meeting with the Oklahoma State Department of Health, again, we strongly suggested that they remove the California testing standards, as Mr. Durbin, you know, suggested. If you want to pick the worst in the industry, literally, California's testing standards are the worst. I think we all agree we need testing standards, and I think that is something that we left out of the law. And I think that you will see, as the industry turns up, everyone, yeah, we have to kind of for labeling requirements anyway, but everyone test. Now, I'll tell you this, what we suggested that we use to the Department of Health was the Illinois standards or the Nevada standards, both of which are very well thought of, both by industry and by regulators to be proper standards. But I'll tell you this just from, and I have an herbal products company. I mean, that's what I do in my daily life. We build and provide natural products. We're under FDA auspices. We have to do certain things to basically maintain a quality program and ensure safety. The standards that we suggest for marijuana are far, far over and above what we have to do in the natural products herbal supplement world. And again, we're agreeing to this, and we want this because we want to protect consumer safety. The other thing that we want to begin to do is really set this industry up for FDA guidance because, you know, like it or not, might be next year, it might be 5 years from now, but this industry will be under FDA guidance eventually in some form or another. So we might as well kind of set things up, and testing goes to that, and kind of regulations, you know, in process and labs obviously go to that.
And Representative, we've had extensive language on this in our proposal. It's largely derived from Colorado, and then have had subsequent amendments to this from suggestions from folks within specifically the laboratory and testing portion of this industry. One area where I'll differ here is that we're ultimately talking about a medicine, and I think a lot of the approach for folks here in Oklahoma, especially in the medical community, is to have similar standards put in place for this as far as quality control goes, research and development opportunities. So we would like to see this treated like any other form of medicine beyond a supplement.
Okay. I've got about 30 seconds probably. I'll just one more question. So the providers that are going to be writing these prescriptions, are they going to be using the PMP to monitor prescriptions for medical marijuana like current medications?
Ron Durbin, Green the Vote. Under the current regulatory scheme proposed yesterday by the Department of Health, they're going to have a system for validation and verification of a patient's license that's available. My understanding is it's going to be voluntary. So I would advocate that there does need to be some way to screen this for, and I think what you do it at is you do it not at the doctor level, I think you do it at the dispensary level. That's the easiest place to do it. They can track, and the database could track what prescriptions have been doled out. They're going to have to check it anyway. Don't put that burden on a doctor. Keep it with the dispensary for checking in a statewide database of what has been dispensed under that patient account in a given period. That's the way to implement that and keep the burden off of the doctors. So.
And Representative Scott, New Hill Solutions, Oklahoma, to respond to your question, there's multiple platforms like this in place in other states that actually manage how submissions and registrations actually integrate into these management systems. So we've proposed language for one that's basically what we see in most communities that have accessibility from both physicians, from the dispensaries, and from the regulatory agency.
Okay, thanks, gentlemen.
Thank you, Representative. Members, with that, we are going to take a 10-minute break, and that is a real 10-minute, not 10 minutes worth of questions. And we will be coming back at 11:50, so it's not 47. So you get 13 minutes. 10:50, we are coming back. You can have 13 minutes. All right, if we can take our seats, we're going to go ahead and get started. Thank you very much for keeping it to the appointed time. 13-minute, 10-minute break, kind of like the questions. So Representative Fetgatter, you are recognized. I do want to make an announcement, and I don't think he's in the room, but he's coming back. Representative Dollins from South Oklahoma City is in the room. Was in the room and is coming back. He is He is a representative. While he's not on the committee, I'm going to allow him to ask questions when the committee members are done. If there is another representative that is here or senator that is here and has a desire to ask questions, if they will text me. I think I have the most widely available cell phone number on the planet, but if not, just come see me. And with that, we're going to go ahead and move forward. Representative Fetgatter, you are recognized.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here today and helping us to work through these issues. I want to start off by a comment that was made a little bit earlier about, our schools should be palaces, and there was a question about the off-the-top money. I completely agree that education funding is critical in our state, and I've fought, for the past year and a half to make sure that we did do that. We got the funding headed in the right path. But I also want to bring to attention that it was also mentioned that there's a lack of trust in this legislature. Part of that lack of trust comes from state question initiatives that have promised to fix our education problems and failed to meet that goal. And so that's why you hear Representative Roberts talk about the need for the legislature to have a little bit more control over the dollars that come in so that we can do our job as legislators that we're elected to do, which is appropriate the dollars for agencies. So I just kind of wanted to start there because because you were very passionate about it, and I appreciate that passion because I have that same passion as well. I want to start off with a question. I understand that there are states that, and this is going to deal with the commerce side of things, there are states out there that have unlimited grow operations and dispensaries and those types of things. We look at Oregon, for example, you have nearly 1 million pounds of flower or medical marijuana that was grown that was not able to be sold. And so how do we take that type of, how do we keep from feeding a black market in a situation where if we have unlimited operations and licensing, how do we keep that from feeding a black market? Because people that have a lot of excess could potentially start selling that on a black market over state lines, those types of things. I'm just curious.
So Chip Paul, Clemenster Health. I'll start. I'm sure we'll all have a lot to say about this one. But again, when we did this as an initiative and a movement, it was a principal tenet, really, of 788, to not only provide this as a medicine, but also to provide this as a business opportunity for Oklahomans that wanted to get into business, okay? So and that is why we didn't limit licenses. And you bring up Oregon, but let's talk about the disasters, okay, really. And let's talk about New York and Illinois and Ohio and Arkansas and Florida and all these other states that really have done this. They've tried to limit licenses. And here's the problem that you run into. And again, who's going to be the expert here? Senator McCortney, are you going to decide whether my application's better than Mr. Durbin's? And, what criteria are you going to use to do that? So this is the problem that most states ran into, and this is the very reason why we did not want to do this, because it creates this situation of, either who has more money, who has a better plan, there's some situation of selection that has to go on. And when you have that kind of selection, now you have to have a lot of preparation. And again, I think in New York it cost you literally $1 million to be able to put together the package to be able to file for a license, right? I think it was, you had to show $50 million at wherewithal and things like that. So we very specifically and with high intent do not want to create that situation here in Oklahoma, okay? So that leads to another question. How do we protect the little guy? And again, I think that's a whole nother question. The way that that's been done in other states is with temporary canopy limits. So if you say, like, for growers, we're going to only let you grow 20,000 square feet, and we're going to put a cap on that. That prevents big money, from coming in and doing 100,000 square foot grows. And That's really the situation that you have in Oregon. So you have a lot of big money that came in there that really, built a bunch of big grows and caused an oversupply situation. But really in every other state, it's been kind of the opposite, where they've tried to limit these licenses. They've run into a lot of problems. And, Arkansas is just a classic example, right? It's just a hairball. But, that's what they did there. So we decided to do it different. We think we learned a few things, watching people over the years. So that's kind of why we did things a little bit different. But, yeah. And apologies to you, sir. For last, I was nervous, and so I was a little abrupt with you last time, so I apologize.
No worries.
Chris Moe with Green the Vote. We would have a problem with limiting the number of licenses. We would also have a problem with limiting the plant count, but we would not necessarily have a problem with limiting the canopy size. So we see a way to keep out the big business, as he's just mentioned, and help the Oklahoma grower without decimating 788.
Ron Durbin, Green the Vote. If I could just add something there, one of the things with the idea that you're going to have an oversupply, when Colorado first instituted their medical program, I think a pound of flour was going for, close to $5,000. I think the last report that Colorado released, the average price per pound was about $850 a pound. So you're going to have market fluctuations. This is an agricultural crop, and you're going to have, bountiful times, and you're going to have times where you might not have as much supply. But what we have to remember is that this is passed for medical purposes, and so as the price goes down, the cost of the prescription for the patient, and them to get the medicine that they need goes down. You're going to have a similar situation to where you had the vapor shops when that became a very popular thing. You're going to have people get into this industry that think they have everything solved, they have all these problems solved, they can make a fortune. They're going to fail. But that's part of the process. That's part of the process we want to encourage, because those people who do it efficiently and those people who do it well and grow a superior product are going to be the ones that continue to thrive and grow, and the ones that aren't doing it well, that aren't managing their cash well, are going to fade and be subsumed by the market. That's an okay thing to have happen. So restricting the amount of grow or the amount of product that can be grown by anybody is going to sort of subvert the market, and I think that creates all kinds of unintended consequences. Let the market dictate who should be in the market.
Representative Fetgatter, thanks for the question. Bud Scott, New Health Solutions, Oklahoma. I think the original question is, how do we address oversupply? And how do we address the issue of having an abundance of Schedule I narcotic out on the market? And that's a very real issue. Under State Question 788, there are no limitations. There is no enforcement mechanism. And I think what we're ultimately talking about here is, do we have projections? Do we have analysis on what our projected consumption rate will be here in Oklahoma? What will patient demand look like? Our organization has algorithms based on this that really determine, based on what we've seen in other markets, comparable medical markets. Now, Oklahoma's going to be a little bit different because it has no qualifying conditions like many of these other states do. But we're looking at a demand market somewhere in the range of 500,000 ounces per year. And at that point, you have X amount of production that can meet that demand. So each square foot of production will have such a produced amount, and then what do we do beyond that? So if we're projecting a 500,000 ounce demand for patient demand here in Oklahoma, but we're producing 6 million ounces, what do we do with that product? And I think that's something that we do need answered.
Thank you. Secondly, when we talk about legal limits, I've heard it said that the legal limits in 788 was a 30-day supply. And I've just seen this, on social media, talking to people, in my district, different places. I'm not saying you all have necessarily said that, but I've been told that the legal limits in possession were a 30-day supply. I'm just wondering if you agree with that, and if you could explain, if you do, how do you determine that 30-day supply? Who is making that determination?
Isaac Cavanis, Green the Vote. That's kind of the beauty of medical cannabis, is that everybody's 30-day supply is going to be different. And so that limit was very specifically set where it was set so that everybody would be able to have their limit. Obviously, if you need less than that, you're not going to go out and buy that maximum amount. But it's not our job or necessarily even your job to tell a patient how much his 30-day supply should be. It should be back to the doctors talking with their patient about how much cannabis they should be using. And so the limit set forth in 788 allows that flexibility for somebody to use the amount that they need.
So if I may respond just directly to your response. So you're saying that it's not my job to determine that, and it's not your job, but you all helped create 788, and you put these limits in there, and it's being said that this is a 30-day supply. So my question is...
788 doesn't say it's a 30-day supply.
No, I'm saying, that's what I said. I said it's being said that that's the number of ounces was determined to be a 30-day supply. So my question is, are you telling me that the doctor will say you only need X number of ounces per month, or does everyone allow the total possession limit?
I'm telling you, by the law, everybody would be allowed the total limit, but if a doctor is doing his job, and as a patient, if you're dealing with your doctor the way that you should, that doctor should be going over the amount that you're consuming. Otherwise, that doctor's not doing his job.
Okay.
So Chip Paula, Clements for Health, those limits were hotly debated. DPNROK, you might recall, those limits being debated, when we were writing that, okay? So there was a lot of discussion that went around those limits, a lot, okay? So where we finally landed on a decision, and then what we actually put in the law, or the proposed, was this rationale. So what's the worst case scenario that we could think of, the worst patient scenario? Who would need the most? Okay, and we went to the cancer patient. And if you look at cancer protocols with medical marijuana, they suggest about a gram of oil a day. So that's where the 30-gram supply came from. That's a 30-month. And again, I'm the one that was saying 30 days, okay? So I've said that a lot.
Okay.
But basically, that's the rationale. Was, what do you need for a 30-day supply? Again, what's your standard, prescription? It's 30 days. So what do you need for a 30-day supply in the worst-case scenario? And then how does that translate to ounces or plants? So those are exactly where all those numbers came from.
Done.
But the thing that we did probably not do properly is it should have been and not or. Again, we probably as patients, we need to be granted some rights to hold certain amounts of flour, concentrate, or edibles in a mixture. But the intent there wasn't or ever, so.
So I'm out of time, but I have just a real quick response. But it's my understanding, correct me if I'm wrong, and I'm not trying to be argumentative with this stuff. If I get a license, that license is for 2 years, and that means I can go to any dispensary during that entire 2-year time frame and purchase up and possess the maximum amount allowed by the law. Am I correct in understanding that?
So let me ask for, Chip Paul, Clements for Health, let me ask you for clarification on your question. So if you go in a dispensary, you can, and this is going to be stuff that's going to need to be fixed, honestly, but you can go in and buy 3 ounces, but if you travel with it in your car, you're kind of exceeding, the ounce and a half thing, right? So I think we need some clarity there. But are you asking, could you go to dispensary to dispensary to dispensary and buy 100 pounds, just buying it 3 ounces at a time? If so, that absolutely is, the intent here is to have a medical program. It's not to provide a sneak around the black market or anything like that.
Sure.
We really are, sincere in our hope to do that.
Okay, thank you.
Thank you for your questions, Representative. At this time, I'd like to recognize Representative Rosecrants for questions.
Well, thank you all for being here. I'm State Representative Jacob Rosecrants out in Norman, Oklahoma and Noble, Oklahoma. I've met many of you, and the kinds of questions that I have I'm extremely open for all kinds of questions from my constituents and everybody else from around the state. So what I have here is there's no way we're fitting it within 10 minutes, flat out. So I've kind of had to prioritize. So realize that this is kind of my questions along with some very, very, very concerned citizens' questions as well. And it's open to the whole entire panel, and I will try to be fast. Some of these are pretty intense. Let's go ahead and start with what was the thinking behind prohibiting gun owners from having a medical marijuana license?
Ron Durbin, Green the Vote. That is an absolute fallacy of reading of 788. That's a federal guidance from the ATF on ownership or purchase of a firearm from a licensed FFA dealer. That is not in 788 in any iteration, nor any reasonable interpretation of the widest boundaries that you could find in 788. That is a federal issue, not an issue that we could deal with, or we wouldn't be trying to take guns from people. If you can't tell, I think everybody up here is pro people's rights.
I'll cut in real quick. That one, I kind of expected that answer, but I really was looking for some clarification because it came up a lot. Obviously, maybe some people need to read 788 a little bit closer. I agree with you. I'm going to move on to my next question. Does the panel agree with that?
Yes, ditto, absolutely. We have a constitution in this country. We have a Second Amendment. You cannot take away, under certain conditions, I guess you can, but no, that's sacrosanct. So it's good luck trying to take my guns away. Seriously.
Thank you, guys.
Representative Rosecrants, we actually have specific language in our proposal that spells out state protections for firearm ownership and the right to bear arms, so we just re-emphasize that specifically within the statutory proposal.
Thank you very much. My next question, let me look through here. Some of these are very specific, even this one. I really like this one. Let's go with, so we're assuming there's established medical history that backs up the request for a card. As I understand it, and is said, 2 doctors would have to sign off for a patient not yet 18. So the question, I have a twofold question. First, so both doctors, do they have to have an established history with the patients? Example, primary care physician and a specialist?
So Chip Paul, Oklahoman for Health. I'll tell you, as we were drilling, again, all of this, we circulated a very sort of a law that needed to be regulated, right? It needs a lot of detail, and that should come in regulation. So in discussions with the Oklahoma State Department of Health, what we talked about was absolutely that at least one of those physicians had to have an established relationship with that child. The other thing that we thought was appropriate to specify is that one of those physicians needed to be a pediatrician. But we were way more specific in that, and we get that. When we're dealing with a child and medical treatment of a child, that needs to be specific and well-defined, and, I think everybody agrees with that intent, so.
The rest of the panel agrees. Okay, and the second part of this question is, if established patient-doctor rapport must be set out, but one or both do not consent, because either they disagree with the parent or they do not feel ethically okay consenting to a minor, or they work at a hospital that has publicly spoken out against 788, even though it now is the law of the land. What rights would a parent guardian have to contest the refusal?
Well, Ron Durbin, Green the Vote, they can also go seek alternative advice and create and establish a relationship with a different doctor. Just as any patient nowadays, if they don't agree with the advice of their doctor or don't think the doctor has their best interest at heart, they can seek a second opinion. We're not restricting that in any way, and would encourage anybody that believes that to be the case to go seek a second opinion or a third opinion to get the medication that they think that they need and to try different strategies for treating whatever illness it is that they have.
And Representative Buttscott, New Health Solutions, we've provided specific language on protecting the right of a physician to not have to make such a recommendation, but also spelling out how that recommendation process would actually operate.
Very good. I'm going to kind of, just to clarify too, once again here, this is going to be kind of all over the board because I'm kind of picking and choosing off of a very extensive list of questions that I had and that came up. I'm a former teacher Today's the first day of public schools in Oklahoma City Public Schools. This is the first one I've missed since 2012. There has been so much concern from teachers and from parents about how we're going to look at this through the eyes of public schools. I have answered many questions because I kind of know that it's actually going to be up to it's medication. It's going to be up to the doctor and the patient. Am I far off on this?
Ron Durbin, Green the Vote. I'm a former teacher. Before I went to law school, I taught 3 years in high schools. So I certainly understand the concerns that teachers would have in this area, but it is a medication. It is a treatment. There are already restrictions on how schools deal with medications, on what the reporting requirements are, the doctor requirements, the dispensing requirements inside schools. And I think a school can come up with a system for implementing something that works within these guidelines if they put their minds to it. I don't think there's any reason why they wouldn't be able to do that. You know, one of the concerns I've heard and we've heard is, you know, about smokable form. Well, you can't smoke on a school campus as it stands now, so that's not really a way that a parent could get the medication to their child. There are alternatives to that. The child can be taken off the school grounds if in the parent's guidance to take their medication if that's the only way that they can be delivered it. But there are so many alternatives for how to dispense this wonderful medicine that there's a solution there for everybody. It's just got to be on an individual basis, and it's got to be for the schools to work with the parents for that.
Very good. I agree with you on that. Oh boy, I've got a very, very, very impressive question. I think a lot of these can be answered. I'm just going to throw it out there by a regulatory agency. I'm sure that's what we're going to have to do. And this is my opinion as a legislator and as a parent and a concerned citizen. Let me go with this I think we're running out of time here pretty quick, but I work very closely with people with disabilities, and they are extremely concerned about the cost of the medication. Could you kind of make them feel a little bit better? Will there be some type of insurance protections or you know, will Medicare, Medicaid? I just really need some clarification on that type of thing.
So Chip Paul, Clements for Health. Again, some of those are federal issues, right? Insurance. And one thing that I would encourage all, you lawmakers to do is pay attention to what's going on in Washington right now and at the federal level with the Senate bill. Again, the Senate bill was introduced by Warren and Booker, I think, but Trump is supporting the bill. And that imbues a lot of rights back to the states, banking rights. I don't know that it necessarily extends to insurance, but again, that's a very important question. One of the things that, came up here about really canopy limits and things like that, while it sounds benign potentially to your question, it inures to your question, meaning that will determine pricing, market. And one of the things, marijuana is very expensive. If you're a patient, it's expensive. It's expensive right now. So what's the proper line between industry success and access to patients? That's sort of a market thing, but that's a thing that, when we make these decisions about market caps and things like that, it has impact. So, yep.
Isaac Havness, Green the Vote. Again, we referenced this earlier. I think that there will be an excess of product available on the home grow side that I would hope would be able to go into some sort of charity program to help people who may be in this position where they can't afford their medicine. I can tell you from a business owner's perspective, I own a CBD store in Tulsa, and our products range anywhere from $12 to $450. And I had a customer come in that specifically needed the $450 product. I tried to figure out any way possible to not sell them this product because of the price, and he looked at me very clearly and said, my copay is $3,600 on my current medications. If this works, you've just saved me a ton of money.
And Bud's got New Health Solutions. I think that's a great point, that if you look at the cost of other medications, the comparative cost for cannabis-related products in other jurisdictions doesn't even come close to the cost of those other medications. I think you can look at most communities that have an implemented medical marijuana program. I can't think of one state where the price for cannabis in any of those states is too high, quote unquote, for most patients to afford. Now, There's case law that's coming out right now on this issue. Out of New Jersey, there was just a case that was issued that effectively said that the private employer had to cover through their insurance, they had to cover the cost or reimburse the patient for the cost that they had expended on this product. However, that was a very extensive case. So I think this area of law is developing kind of day by day. So we can't force companies to cover the cost of reimbursement right now. Medicaid, Medicare, obviously it's still Schedule I federal narcotics, so it cannot cover that.
Chris Moe, Green the Vote. I just want to give you some numbers from an actual patient perspective. 3 years ago, my medications cost around $900 a month. Those are opioids and all kinds of other mood enhancement drugs, almost all of which I've replaced with cannabis illegally. Runs me around $500 a month. When a dispensary opens, it will probably run me around that same amount. This is why the home grow is so important and why not limiting the number of licenses is so important. I understand canopy size will affect price too, but if we have enough businesses out there, I don't care what you limit the canopy size to, we'll have enough. And the price is extremely important because I've been to other states. I know what it costs. I know that me surviving on disability, I would not be able to afford it if I could not grow it myself.
Thank you, Representative Rosecrants, for those questions. And at this time, I'd like to recognize Representative Loring for questions.
Thank you, Mr. Chair. I want to thank you all for the open conversation here. Let me start with what I think are the easiest questions. It's not clear, and I just want to get your input, is there a multiplier effect? In other words, if a household has 2 people with licenses or 3 people, can that household have 12 plants or 18 plants as opposed to just the 6?
So Chip Paul, Oklahomans for Health, yes, they can. So again, and I know if you're not kind of familiar with the industry and, you know, kind of how this works as a medicine, that seems or could seem somewhat threatening. But again, you have people that are really, you know, the intent here is to have people literally growing their own medicine, and we've kind of established, you know, 6 the right number of plants. Well, we thought so and kind of put it in the law that way. But you should have the right to grow 6 plants if you're a patient. I should, and if we live under the same roof, then, you know, that's 12. So, yeah.
All right, so
I would like to add to that. I'm sorry, Chris Moe, Green the Vote. Keep in mind that they've got to have the room to grow that. So just because there's 3 card holders in the house and they can now grow 36 doesn't mean they suddenly have a wing on their house they can turn into a grow. Or everybody has a yard big enough for whatever it is that you might be worried about numbers-wise. So please keep that in mind. Just because everybody in the house has the right to grow it doesn't mean they're going to grow the full maximum amount.
one of the things that I was curious about that 788 did not address, and that is in the current law at Title 68, Section 450.2, there is already in place a tax of $3.50 per gram on marijuana. That is not at all addressed. Are you assuming that we're going to repeal that?
Chris Moe, Green the Boat. I worked on 3468 with Representative Jordan earlier this year, and I can tell you that was our full intention to get rid of that. I've actually purchased some of those stamps. Someday those will be collector's items. But yeah, we did address that. Not here, of course, but we've talked about that. That needs to be eliminated.
Ron Durbin, Green the Vote. If I could add, that is one reference to one statute where there is a problem with 788 and existing statutory statutes that are in effect right now. The Department of Health in one of their new regulations adopts part of the food code, which is 63 OS 1-1101 at SEC, I believe, is the reference. And in 1102L, one of the standards says you can't label any product with a controlled dangerous substance name. Well, if you label the products correctly under the statutory scheme and label it cannabis, you've now made it illegal because this law conflicts. There are lots of areas that this legislature needs to address as it works through how to properly implement this. You know, we have to commend Chip and all the people who advocated for, you know, getting 788 passed, but there is a lot of work that still needs to go into this. That's one example. Other criminal statutes dealing with, you know, cannabis being in a food product or adulterated food products. There's lots of areas that need to be addressed in this. Rachel Bussett, which the committee may or may not know, and I were ones that were meeting with the Department of Health this morning. We brought up some of these issues. I think a lot of this, though, has to be you guys because there's statutes that conflict with what we're doing. So there's areas that we can leave to a regulatory agency, but the areas where there's this conflict of ideas between 788 and existing law has to be addressed by the legislature and needs to be done in a comprehensive way.
Rachel Bussett for Oklahomans for Health. I also represent the individuals in the lawsuit down in Cleveland County. I've listened to all of the questions this morning, and I think one of the most important things for all of us to remember is that 788 only created 8 new statutes in Title 63. We have 85 titles and I don't know how many statutes under Oklahoma law in addition to the administrative code and the Oklahoma Constitution, and the passage of 788 and the creation of those 8 statutes didn't make all of that other law poof and go away. It still applies, guys. It's still there. 788 works in conjunction with probably 95% of it. It supersedes maybe 1 or 2% of it, and it's in conflict probably with 2% of it. And that's where y'all have to come in and do some work. There is work that needs to be done. This branch is the legislative branch. Y'all are charged with enacting the law. That's your role. The administrative agencies, they're part of the executive branch. Their role is to enforce the law. In order to enforce the law, y'all have to delegate authority to them through enabling language. 788 has very limited enabling language in it to the Department of Health. At the end of the day, while the Department of Health is what was chosen in 788 to implement this program, it's really not the appropriate agency because 788 goes across multiple disciplines: medical, pharmacy, agricultural. What really needs to happen in having a legislative fix, because there are holes and there does need to be some legislative fix, at a minimum there has to be this legislator giving the appropriate enabling language for an administrative agency to make the appropriate rules. But y'all need to create a title that relates to medical marijuana, especially if 796 and 797 get on the ballot and pass. It looks very likely that they're going to get on the ballot. We already know that there's enough signatures for 797, and if that is slow paid and doesn't end up on the ballot, like it's been reported in the news, you're going to have a big backlash on that. I don't know where they stand on 796, but the last I heard, they were pretty close on the signatures. I anticipate they're going to have all the signatures that are needed to have 796 on the ballot in November along with 797. I encourage everybody in our government to work to put this to a vote of the people so that when y'all come back into session next year, we can get everything done that the people of our state want with regard to medical marijuana, recreational marijuana, whatever it is that the will of the people want, and that y'all come in and you do it right once, and you do it right the first time. You create an agency that is for marijuana in the state. You create a title that is for marijuana in the state. That you do what the people intend, that you look at this as a medical bill, that it is not for you to prescribe what the people are allowed to take, that it is for the doctors to prescribe. While it might seem like a lot to all of you or even to me for 3 ounces or 72 ounces of product to be in one person's possession, You do not know as a non-user how that affects them, what their tolerance is. I was on pain control for many, many years and was dispensed 60, 90, and 120 tablets of opiates for a 30-day supply. I submit to you, that is a lot of opioid medication to be given to someone. I submit to you, it's a lot to ask for 2 physicians to sign off on medical marijuana for someone under the age of 18 when nobody had to second guess my daughter's primary care physician when she was prescribed opioid medication because she broke a bone. I submit to you, it's not for you, unless you've been to medical school, to second guess what a doctor says in the privacy of the room. The people intended for all of this to go through, I appreciate that you all have come here. I appreciate that all of these groups are working together. We need legislation. We need the gaps to be filled. But the people intended for this to happen as it has gone through, we need to all work together to fix it. The people intended to fund education and drug and alcohol rehabilitation, and I'm asking the legislature to rebuild the trust that we talked about earlier, lacking in all of us to come together to fix these rules and to build the trust that Mr. Durbin and I talked about with the commissioner over at the Department of Health this morning.
We're going to have to keep our answers shorter, so we're never going to, guys, I work notoriously long hours. I am here till early in the morning, late at night. It is nothing for me to stay here as long as you guys want to stay here. I just want to be clear. Come hang out during session, and I can't complain to my speaker because he's the only one that works longer than me. But we have got to keep it a little bit shorter. We're never going to get through all this. But
And Representative Echols, just real quick.
again, keep it short, and then I got to let Representative Lonnie ask another question.
Absolutely, just on the tax stamp, let me just say this, if you didn't repeal that, that leads to about $126 an ounce. Shockingly, that's probably about in the range that the market will land anyway. So, I mean, we would appreciate it if you did repeal that, but if you didn't, you kind of fixed a price in the market. So.
I'm going to give you some more time, Representative. Keep going.
Thank you. So what you said led into another question. Again, 788 is not clear on this, but I'm assuming that we're all talking about when the patient meets with the doctor is an actual face-to-face consultation as opposed to, for instance, a doctor that just signs off on these cards over the internet.
Ron Durbin, Green the Vote. We would agree with you that it should be a physical interaction between a patient and their doctor. While telemedicine is a wonderful, fantastic thing in a lot of regards, it's not something that should be advocated, at least in our opinion here. That doctor-patient relationship is important. I think one of the concerns that's premised in your question is teleconferencing with out-of-state doctors that get a license in the state of Oklahoma for purposes of writing a recommendation here. Certainly restrictions can be put into place to kind of allay those fears and make sure that it's a doctor-patient relationship. I think 788 already does that and requires a doctor-patient relationship.
So, Chip Paul, Oklahomans for Health. In going through this with the Department of Health, I mean, there's intent here really with this doctor-patient relationship. I mean, and it's very specific. We want that doctor-patient relationship, absolutely. We want that to be well-defined. But we also, and absolutely telemedicine was envisioned in this, no question. I mean, I know what I'm thinking, and telemedicine absolutely was envisioned under 788. But again, that telemedicine can't be like it is in California. In California, you dial up a guy and you tell him your condition and he agrees with you, medical marijuana will fix that, and he signs your thing. Not here. We don't want that here. So telemedicine, but with a defined doctor-patient relationship in a similar way that it is if I was sitting in front of you in your office. It has to be well-defined, and that's very important. That's a very important intent under the law. We want that well-defined.
So the chair is very kindly giving me one more question. Let me go to one that I probably have the most concern about. and that is liability issues. I mean, I can foresee lots of lawsuits coming against doctors, against dispensaries, kind of a dram shop type theory type thing. You know, if for instance, a dispensary were to sell to somebody that they legally should not have sold to for whatever reason. But I can see lots of potential lawsuits coming out of this. I'm concerned about, for instance, doctors with medical malpractice. Would they be covered by that, by their malpractice insurance? Can insurance protect those individuals, and in other words, protect society as a whole, when we're dealing with a product that is, at least at present, federally illegal?
And Representative Buttscott, New Health Solutions, Oklahoma, thank you for that question. And if you look actually in our section related to physicians, we specify about non-liability for physicians for either administering or recommending this product. So a waiver from both civil and criminal liability on this matter. And I think this is the way this should be approached. There's going to be litigation in this regardless. I think we're going to see a lot of this flesh out, just like we do every industry.
Chip Paul, Clements for Health. You know, we really don't see a lot of lawsuits and things like that around this industry in other states. And again, that's public record. You can look that up. But certainly things get challenged, right? So, you know, when we look at the doctor-patient relationship, we want that to be tight. I mean, honestly, we want the doctor on the hook. You know, he needs to have legal, ethical, moral responsibility in that decision. So that's, you know, if he needs to insure his way out of that, fine, but we want him to have skin in the game. That's important.
Ron Durbin, Green the Vote. This area, I was waiting for this area to come up because it is a concern, I think, for everybody. It's a concern for doctors, it's a concern for dispensaries, it's a concern for everybody. One of your questions was, is a dispensary going to be held liable for dispensing this? Well, they're doing what's allowed by law, so that would kind of kick out negligence per se from what they're engaging in. But I think you would apply a general negligence standard there, and that same as if a pharmacy improperly prescribes or dispenses medication to somebody or gives them the wrong medication from what they were supposed to get, they're still going to have potential liability there. Are there areas that the legislature can tighten up? Absolutely. There's areas with regards to operating motor vehicles where it could be a potential problem, and there could be a negligence per se type issue there. All of those things do need to be addressed by this legislature, providing the doctors some protections. Providing them blanket protection as might be proposed by New Health Solutions, probably not. Because if a doctor is acting outside of acceptable standards, they should be still held responsible for their actions and for their negligence. There is a compromise and a window here with which to work 788 and medical cannabis into all of the intricacies. And I practice primarily civil litigation doing these kind of lawsuits that you're worried about. And I think there's a way to accomplish it while not creating a special law, which the legislature has a tendency to do, and while not going too far, which the legislature has a tendency to do. It needs to be narrowly construed, narrowly drafted, but to provide some protections for those areas that you're concerned about.
Thank you for that. Leader Kouplen, you are recognized.
Thank you, Mr. Chairman. Thank you all for being here and bringing a lot of information to us. And I have so many questions and I don't know where to start, but I'm going to follow up kind of on Representative Loring's question. The doctor, and I heard someone mention earlier that, I mean, how familiar is the medical community with really prescribing the amount of medical marijuana a patient needs? And is a nurse practitioner in rural Oklahoma, we have a lot of nurse practitioners that take care of our people, not doctors. Will they be able to sign off on these?
So Chip Paul, Clements for Health. No on the physician's assistant. You know, you have to be a board certified, and we'll probably argue over that forever what that means, but board certified physician here in Oklahoma. What was the first part of your question again? I had an answer for you.
Well, the knowledge that the medical...
Oh, yep, very good, so perfect. And again, this is part of why this was written this way, and it, you know, what I do every day, what I do for a living, again, I have an herbal supplement company, but I research the endocannabinoid system. And I know to a lot of you that sounds like I'm a snake oil salesman or something, but I'm very serious about what we do, and I read research papers on this medical system all the time. This is what medical cannabis affects, the endocannabinoid system, okay? And it turns out it's literally your master regulatory system. It runs every single function in your body, and it's manipulatable by medical cannabis. It seriously is like a master screwdriver into your body, into how your body functions. But no physicians know that yet. So this is just beginning to be taught at major schools, medical schools and universities. I'm actually humbly privileged enough to be able to be inputting into one of the first classes at a major university where this should be taught every day, a PharmD PhD level class. So I apologize to kind of go around the corner here, but to your point, no, physicians don't know about this system yet. That's why what we're doing here in Oklahoma is so important nationally. Because how do you drive pressure on a physician? How do you drive change into a physician community? They're not changing around the medical marijuana condition. They haven't, right? You don't see physicians with a lot of knowledge about this system yet. This is why this is very important, what we did here in Oklahoma, because we'll shame them, frankly, here in Oklahoma into learning about this system. How many times will your family doctor hear someone come in and say, Doc, how come I can't get how come you won't prescribe me medical marijuana for this condition? It won't take long before he starts reading and researching and understanding about this incredible system that can literally treat, you know, and again, I apologize to diverge, and I'll take about 2 more minutes here. But if you think about this, consider let's just go to the pain spectrum, okay? The pharma pain spectrum, okay? And you think, if you come to me and you say, I have pain. So on one end, I can prescribe you ibuprofen, NSAIDs, right? We all know what those are, anti-inflammatory drugs. Those have contraindications. They are not safe, Hurt your liver, stomach, all that. Go to the other end, you got opiates. Those kill you, right? So when you go talk to your doctor about pain, there's nothing in his pharma FDA, pharmacopoeia that he can prescribe to you that's safe. We're giving him a completely safe option, okay? So he needs to understand what that means, how powerful that is, how it should be prescribed, under what conditions it should be prescribed, under what conditions it shouldn't. But the only way that we're going to drive that is by leading that. And we have an opportunity to do that here in Oklahoma. We've given you a piece of legislation, a piece of law to lead here. So your question is incredibly important. We're going to educate them. We're going to shame them into learning. But we'll have avenues and opportunities for physician education, absolutely. And that'll be done through potentially through the trade organization. I know there's a well-known expert in the field, lady named Dr. Regina Nelson, who's interested in setting up, CEU-type classes for physicians and things like that. And I apologize for the long answer, but you asked a very important question.
Ron Durbin, Green the Vote. There's no national standard set on dispensing amounts or doses for medical cannabis at this point, if that's what your question was, and I think that's exactly what your question was. It's a situation where doctors who are going to recommend this are going to have to work with their individual patients and determine proper dosing levels and those things in conjunction with their relationship and ongoing relationship with their patient. But there are no national dispensing and dosing standards at this time.
Leader Kouplen, Bud Scott, New Health Solutions, Oklahoma. To answer your question about the PAs or the assistants in the scope of practice issue, in a lot of our feedback that we received on our proposed legislation, we addressed a lot of these issues because in 788 it says an Oklahoma board certified physician, which There's several definitions for what physician actually means. We settled upon a section from Title 52, which describes a very specific set of physicians. It's where it's defined in statute, but ultimately this will be up to the legislature to make that determination on that scope of practice portion. I think there's a lot of concerns about accessibility, as you're well aware of in rural communities. There may not be an abundance of MDs or DOs to make these recommendations, and so we should have a little flexibility in which professionals are medically trained and capable of making those recommendations for each patient. I will say, if I can have just one more second, Representative, that under the guidelines of 788, this is just one more reason why we need to specify this and clean it up in legislation. The Health Department has attempted to claim that only MDs and DOs can participate in this program, and that is well beyond their statutory authority.
Any other comments from anybody? I've got some other questions, but my time's probably getting short here.
You got about 3 minutes if you want them.
So I better go to the original question. 788 had some timelines in it. What do you think is a realistic timeline for us to get proposed fixes done to implement 788? And when I say done, do you believe that the Department of Health can implement 788 without the legislature adopting statutory rules?
So Chip Paul, Oklahomans for Health, I do. I think that they can. Again, right now, they're being driven every which way from Sunday, right? Where we got to on Thursday was a really good place. I think we conceded points and they conceded points, but we got to a really good place Thursday afternoon. We spent 3 hours, with Interim Commissioner Bates and his staff. That's not really what you see that's out there today. And again, they're being driven all over the place. But that's what they do. They regulate, and they frankly, I've read these regulations for 4 years. I've lived in this stuff for 4 years. I've talked to state regulators. I've been all around this country with this issue. Our Department of Health, for not knowing anything and just getting started, and spun up, they've done a fantastic job. So, I think if we roll back to where we were Thursday, again, if they adopt what they did Tuesday, today, that's workable. If we roll all the way back to where we were Thursday, that's a really workable program. Does it need to be adjusted? Yeah, absolutely. It'll need to be tweaked and fixed and all that. But again, we won't really know where the warts are until we run it a little bit. I think we know that we need probably, a regulatory commission. I think we'd all, agree to that. But definitely the Department of Health could, if everybody kind of leave them alone, produce something I think that's workable and that we would agree to as proper under our law.
So, Ron Durbin, Green the Vote. With regards to leaving the Department of Health alone, they've shown that we can't do that. Their current regulations make it legal and then make it illegal at the same time. So leaving them alone, I don't think is the right course of action with regards to that. But as far as a realistic time frame, you've got New Health Solutions that have offered a now 70-page shorter version of statutory schemes that could be implemented. We, with Green the Vote, have offered statutory schemes that I think total about, 34 pages. There's framework in both of those. Certainly we don't agree on everything. There's no doubt about New Health Solutions and Green the Vote agreeing on everything. We think they go too far. They think we don't go far enough in some areas. But I think if you sat down with both of those schemes and frameworks and 788 as the guiding principle of that, you can come up with a regulatory or a statutory scheme and statutory framework to properly give an agency the ability to regulate this industry and do so in an expeditious fashion. I think that if you work towards that goal, which I believe this committee is doing, you can get there quicker. Can you stop the train that is 788? At this point, no. There's not going to be a call for a special session that I'm aware of from the governor, so you're not going to be able to do that. So you've got to work with inside of what's already going to be in place. But I can tell you right now, we're here back again this week We'd probably be back here tomorrow if you guys asked for us to be here tomorrow to try to work through point by point, statute by statute, what issues there are, and try to come up with something right now. I'd be here, I can guarantee you Bud Scott would be here, and I know Chip Hall would be here, Isaac and Chris would also be here. We're here if you need us, and I think that's what needs to happen if you want to get something in place quickly.
And Representative Bud Scott, New Health Solutions, I think we fundamentally disagree that the health department can implement this in a responsible and timely manner. I think they're doing their best to do this, but the timelines that they've been forced upon, or that have been forced upon them, you're asking an agency to start issuing licenses for this industry basically August 25th. They have to start accepting applications. There's a 2-week turnaround period by virtue of State Question 788. That means you're asking an agency to issue licenses for companies that will be making a controlled substance, and they haven't even had site inspections. They haven't even had plumbing inspections. They haven't had fire code inspections, something that every single business in the medical industry actually is required to go through. So it's clearly been our contention that if we do not address this during that 2-week window, basically from August 25th until that 2 weeks is up, with them having to issue licenses to potential business applicants, we are opening a gigantic can of worms. And this is just fundamentally bad public policy. We really need to address this to set forth how these programs will actually operate. And we believe we're trying to provide as many recommendations as possible for your legislative body to consider. But yeah, we fundamentally believe that we've been calling for it the whole time, special session.
Yeah, and again, Chip Hall, Oklahomans for Health, that we don't think we need a special session. And again, we do think that the Department of Health is absolutely capable of implementing this. And again, the times are there for a reason. I'm an entrepreneur. I'm optimistic. I think we can do things. I think we do things fast. Why not? The Department of Health we have patient licenses up. They've sort of completed task 1. They've selected an IT vendor, to do all this. So they're moving fast. They're doing a great job at the staff level of doing everything that's required here. So is this going to need to be fixed? Is this going to need to be probably changed and tweaked and massaged? Yeah, but again, we put it at the Department of Health. They're responding. They're doing what they need to do. I can't believe I'm sitting here defending the Department of Health after everything has happened. But, if we can get past the board level there, and again, we'll see if we can do that. But the staff there has been, they're regulators. This is what they do, right? If they live in these regulations every day, they understand this, they understand how to tighten things up, so.
Chris Moe, Green the Vote. I'd just like to say, I understand what you're saying. There's a lot here to work out in a short amount of time. Here's where I stand. Special session, not special session, don't really care. Patients need to get their cards as fast as possible. If you can figure out some way to roll out part of this so the patients can get their card and start growing their own medicine and stop worrying about getting arrested, I'll support you. If the whole program gets slowed down because you're trying to work out some of the business problems, there's going to be some backlash. And I mean that with all due respect, but we have patients that need their cards as soon as possible.
Thank you for those questions. Senator Jech, you are recognized.
Thank you, Mr. Chairman. One of the advantages of going late in this process is a lot of my boxes have been checked, but I would like to follow up on a few things. I appreciate the other committee's questions. They're very thorough and well thought out, and I appreciate the responses that we've gotten so far. I think one of the challenges that we've maybe defined today is that this is a cumbersome process. How do we get there? And maybe we just talked about the timeline. Maybe the timeline, we want to do it right, but what my definition of right, her definition of right, your definition of right, how do we get there? Most of what comes out of this building is a result of compromise, and that's an arduous process, and it's there for a reason. I think, Mr. Scott, you mentioned last week, maybe again today, but you mentioned last week, there's a reason you put those aggressive timelines in there, because you want it to happen, and I get that. So how do we get there? That's my question, and I appreciate this process. We've got other groups to hear from. I appreciate your willingness to be here, but there are other groups that this committee needs to hear from going forward, because this is going to have to be a work in progress as we go forward.
You're welcome to comment on any of that if you'd like, but one of the questions that I have, we've talked about federal law a lot. Like it or not, this is still an illegal substance as far as the federal government's concerned. So how do we look past that? Banks are bound by that, and they're playing by those rules. So are you concerned that if, I think, Mr. Durbin, you said some of those laws are being relaxed? Maybe they are, but maybe they aren't. But if that doesn't happen, what if they go the other way? What if they decide to crack down on the states that have passed medical marijuana or marijuana in some form? How will that affect this your business, and how will that affect the state in general? And you can comment on that, and maybe some of the others as well.
Sure. Ron Durbin, Green the Vote. Unfortunately, the Commerce Clause of the Constitution authorizes the federal government to regulate things that are in the stream of commerce. They have wide-ranging authority to usurp the power given to the states under the 10th Amendment. We all know that, and we understand that. The federal government could go either way. As the tides change, things could change. If they went more stringent, that's certainly going to impact every single state that has a medical or recreational cannabis program. I think that the tides have turned and the poll numbers have turned to such a degree that is highly unlikely for them to do that. It's just too widely accepted in too many states. 30 states have either a medical or recreational program of some kind or another. So I don't see the federal government going more stringent. As far as the banking issues are concerned, the state can authorize and allow banking institutions to be instituted that apply and only operate inside the state, and therefore they don't have to have the FDIC or the credit union insurance from the federal government. The state could take action there to try to carve out some kind of banking system related to this industry. One of the things that the regulations should do, or the statutes should do, is it should create tight financial reporting requirements for these businesses to report so the state can track money, track taxes that are supposed to be paid, those kind of things. But opening an avenue for businesses to be able to bank in a realistic, non-cash manner is something that we should strive for. No other state has really come up with a great solution for that. We're given an opportunity to try to come up with something, and a state-regulated banking industry specific to this market would be one way to go, and we would encourage you to look into that.
Chip Paulo, Clemens for Health. If you look federally, you can kind of, I would say in our community, we were uber scared of the Trump administration, and mainly because of Jeff Sessions, right? So I don't think it can get any worse, and I'm a MAGA guy, I voted for Trump, so I'm a Sessions supporter, but as far as our community goes, I don't think it could get any worse than a Jeff Sessions as Attorney General, okay? And you look at what he did, and he repealed something called the Cole Amendment, and that caused great furor in the cannabis community. But you've seen how that community has responded, and again, that community has responded federally with legislation. You've got, all the Colorado lawmakers just up in arms about that, and so you've got a lot of pushback federally, and I think that's been recognized by the Trump administration, certainly by their support of this Senate bill that again, it's initiated by Cory Booker and Elizabeth Warren. You've got two, people on the extreme left, and then you've got, President Trump on the kind of the extreme right also supporting this. So I think you're going to see federal action probably in the next 2 years here. But just consider this, 30 states have medical marijuana programs. I mean, we certainly have the power to call a constitutional convention and have our way. Right? That's certainly possible. And I think that's kind of the federal threshold. I think our state, if we somehow get recreational, adult use marijuana on the ballot, and again, I know that probably scares the heck out of everybody worse than, medical, but we're the tipping point. We'll be the tipping point federally if that happens, I believe. So, but there's a lot of attention and focus on this now. And to Mr. Durbin's point, we do need banking solutions, and again, that is something that will somewhat fall to you guys or the tribes, frankly, to help us with as an industry.
Senator Jech, Scott, New Health Solutions, Oklahoma. The legislation that's being referred to is the States' Rights Act in D.C., and it's Senator Cory Gardner, who's a Republican from Colorado. That's the co-sponsor with Senator Elizabeth Warren out of Massachusetts. Unfortunately, what we're looking at this point is that we have legislation in D.C. we can't depend upon the movement in Congress to base our industry around. So there is a need for us to come up with some local solutions to this. I don't think that it's prudent that we'd be able to address this at this moment, but perhaps, and that's something we've been speaking with the Banking Commission on and several different banking entities here in Oklahoma, as trying to reach towards a regulatory and statutory solution for this, that there's other examples in other jurisdictions, notably Oregon and Colorado, for their credit union language that we could pursue here potentially in 2019.
Thank you. Mr. Paul, I want to go back to the amounts possession that are spelled out, and you talked about that a little bit, that was greatly debated. I think you said how you arrived at those amounts. So those amounts that you came up with that are very specific in 788, how do those compare to other states that have medical marijuana?
They are not the highest by any means, but they're higher than most states. And again, the intent there, our community is very concerned about law enforcement, breaking in the front door and where is that line? Okay, so where is the legal line? Some people in our community literally break, they're great citizens, they break one law. They're just like you, but if you broke one law, but you felt valid in doing that, you would be very concerned about how that law gets enacted and put in place. But certainly when it comes to, your house, your personal freedoms, okay? So we wrote that with the intent to provide a maximum where we wouldn't have our doors broken down, frankly, and that's really where that came from.
So, Mr. Scott, Mr. Cavanis, did your drafts, do they mirror those same limits in what you've presented so far?
Yes, Senator, we had the same limits because that's what was approved by the vote of the people in 788.
Yeah, Isaac Cavanis, again, everything that we've tried to put into place in any of our ideas have been a direct result of the language of 788.
Thank you. On the taxation issue, kind of the same question. So 788 calls for 7% at the retail. Same with both of the other drafts? It's the same?
Yes, and for the same reason, and there's an argument to be made. I think it started to be made earlier that most medications aren't taxed. We would love to see that tax go away, but we have to be realistic about the fact that there's going to be a need for an amount of money to make this regulatory system be able to function.
And Senator Scott, New Health Solutions, I would echo that exact sentiment. We kept the 7% in our proposal, primarily because the restrictions on State Question 640, we don't believe that we could actually include in a legislative package unless we had a supermajority vote to support an additional tax increase on this.
And you're in agreement that the state and local taxes are in addition to that 7%, I assume?
So, clarify what you mean. I'm sorry, Chip Paul, Comes for Health. Clarify. Like a sales tax?
Well, just the sales tax that would apply to any other product, state sales tax?
No sales tax on this product.
There's no sales tax on
No,
it?
sir.
Ron Durbin, Green the Vote. I don't think that's the way that the Oklahoma Tax Commission is interpreting it. They're interpreting the 7% and 788, rightly or wrongly, as an excise tax, which would be a tax in addition to normal sales and local taxes. So it'd be, I think Bud actually mentioned the number earlier, 15.5% is what it should roughly come out to. Well, again, rightly or wrongly, that's how they're interpreting that 7%.
And Chip Paul, Clemens for Health, that's a 7% tax. There's no, I know it says sales, but again, the intent there was a 7% tax on marijuana sales, no additional sales tax. That was the intent. So again, right or wrong, do municipalities need a piece of this or whatever? The 7% was there as the only tax, and that 7% was to go to the Oklahoma State Department of Health.
So that's the intent of 788, is that would be, there would not be sales tax, state or local, in
It's a
addition to that.
medicine. It's a medicine.
But the tax commission's not interpreting in that way.
I know.
So if it's open to their interpretation, then that leads me to believe that there will be some challenges whichever way they go with that, which could lead to a 640 question.
That's a debatable, should there be a sales tax on this or not?
That's a hot debate. I would argue no, and I would argue no, that our intent, was not to have a sales tax. I completely understand the reason for a sales tax and the need for a sales tax. So is that we have to poll the community, honestly, is that a live or die issue, for our community? And I'd want to know what they think, really, but it's open to interpretation right now.
In you all's knowledge, has the AG weighed in on that question to this point?
Not yet.
Senator Jech, the Attorney General's office has not weighed in specifically on that issue. The Tax Commission has. They've been very clear that they're treating this as a excise tax in addition to the sales tax. Now, if that's something that needs to be clarified, it's just add that to the long list of things that we can address through statute.
I'll ask one more question on how I'm doing on time, but one of the points we talked about a little bit is the validation system, the PMP program. So, Mr. Cavanis, I think your bill addresses that in the very beginning in the application process. I think it addresses that. So,
Ron Durbin, Green the Vote. There absolutely has to be a validation system of medical licenses. I mean, we have, as an owner of several bars, we have situations where people present fake IDs, but for us scanning those codes on the back of a driver's license, we would be letting people into the bars that are under the age of 21. We don't want that to happen. This industry can't let that happen. So there absolutely has to be a validation system in place to validate the legitimacy of a medical cannabis card. One of the concerns that I had from the meeting this morning is that the way that they're regulating it now is going to be, there will be a voluntary phone-in system to check on the validity of it, but it is not going to be mandated or required. I think that's a problem. The problem stems from the fact that they don't have the authority to regulate that area by enacting language to give them that regulatory authority to put that in place. But that is absolutely, along with all the other things that we've talked about, things that need to be in place, laboratory testing, all of those other things. There has to be a validation system, or this system is going to be what it is all the proponents were against, which is a system that's kind of the wild, wild west. And we're not advocating that. We want a system that works.
And Senator Putt-Scott, New Health Solutions, just to add upon Mr. Durbin's comments here, what you typically see in another program for regulating medical marijuana is you see a patient registry database. You also see inventory tracking systems, and those are all proposed within our legislation and pretty well fleshed out as well, with models that we've seen be successful in other states.
one more question, Mr. Chairman. I think this is just a definition. So under this is section 1, Mr. Scott, so if you could tell me what is concentrated marijuana and what is edible marijuana? Whoever wants to respond to that, I don't care.
Since you asked specifically, there's various kinds of processed marijuana products, and as this industry has evolved and as people's really entrepreneurial spirit has evolved, there's a whole range, everything from edibles, that means it's generally a product infused with the oil that is extracted from a cannabis plant, so you can refer to them as edible infused products. There's also straight extract, where it's the oil that is pulled from the plant through a variety of processes, whether it's a water-based process, whether it's a heat-based process. There's multiple ways of doing this, and you can pull that out and turn it into a concentrate, which is either an oil or something like shatter or wax or hash. So these are all of the varieties of processed items.
Mr. Paul, I apologize, that might have been, you wrote the bill, and that's your terminology, so maybe you're better to weigh in on that.
Yes, Mr. Scott did a great job, but Chip Paul, Oklahoman for Health, he did a great job of describing those different things. But you'll notice, and again, nobody knows about this industry, yet, and I think that's why it's so valuable for you guys to take a trip. I mean, let's go look and see how this really works somewhere. But the reason that we have this interim license called a process license, yeah, you two will be front and center, right? But the reason that we have this whole thing called a process license is for the very reasons that you're talking about. So processors will take, whole plant, raw marijuana, and will basically, through a variety of things, heat or cold or different processes, turn that into oils or turn that into edible products or both, or powders or all different kinds of things. But in a real kind of, pharmacy laboratory way, they'll be doing these things, extracting and doing things like that. So that's the whole reason why we need this process license, is this sort of mid-tier license, and that's how we regulate that whole endeavor.
Thank you, Mr. Paul. And when you said I should take a trip, I think I knew what you were referring to. Just
Industry trip.
Those happen innocently, don't they? Thank you, Mr. Chairman.
It's, unlike 788, it's always good to specify, right?
In two committee meetings, that was our first pun. I'm very impressed with us. With that, I would like to, thank you for that, Senator. I would like to recognize Senator Daniels. After Senator Daniels, I'm going to recognize Representative Dolan's for one question. I'm going to ask mine, and then we will allow additional questions from the committee.
Thank you, Mr. Chairman. Getting to go almost last, many of my specific questions have been addressed, and I have others, but the conversation has gone in a direction that I want to go a little bit more, have you be a little bit more specific with us on the whole picture after the gentleman said that the most important thing is to get the licenses so that patients can grow their own at home, that that's the most critical piece of 788 in your view. Just to let you know, though, what I think my role is and why I wanted to serve on this committee is that ultimately 149 elected representatives and senators of all the people of Oklahoma will be required to implement this final legislation. I don't see anybody in this room as an antagonist. You voted for it, you voted against it. I represent all your views. I do not see law enforcement as an antagonist. I do not see the medical profession, the business community, education institutions. These 2 weeks, I've already learned a lot about a product, a process that I knew nothing about. And I'm going to build on that knowledge. But I also do have to address the concerns of those we have not yet heard from, because this is going to cost taxpayers. Even if ultimately it generates revenue, to set it up is going to require a budget in competition with all the other budgets that we must consider in Oklahoma. So 57% of the people have voted to have maybe a new agency, maybe a whole new set of spending. So I understand that we must work quickly. I would prefer to say expeditiously, because I want my colleagues to know that when I recommend legislation to them that's voted on, they can be assured that we've done our very best to answer all the questions and solve as many problems as we can, because we also know litigation costs taxpayers as well. So, having given my little speech, here's what I'd like to know from each of you. What are the 2 or 3 most important things about 788 that we should focus on now? And I'm using your comment about licenses for the people to grow it at home. That would be one. So to help me direct where I really need to focus, what are the 2 or 3 most important things you think we should be addressing?
Chris Moe, Green the Vote. I'll start this off. I'll just build on what I said. Patients getting their licenses is something you guys need to do as soon as possible. Another thing would be addressing some of the law enforcement issues, because until the patients have their cards, we have law enforcement that are still, as they say it, upholding the current laws. So from my standpoint, it's the cards, it's the legal system, or the laws that are getting people arrested, and with the cards comes the home grow. You guys can work out the business stuff, we can start growing. We'll be on track to have our own medicine about the same time the dispensaries do, and if we have to wait for the business end to get lined out, we'll be 6 months behind them. I mean, we'll spend the next year trying to catch up, and we'll go without our medicine. And again, that's my main concern, is that everybody get their medicine as soon as possible. So, thank you.
And I just chip all Clemens for Health. Absolutely what Chris said. Patient access is number one. But that's a little bit bigger question than just providing, patient licenses, right? That means there's access in some kind of a business situation where those patients, can access medical marijuana. So those two things are the most important things. Clearly, we wrote the law, we expect the law to be honored. 57% of us, said yes, so we expect, some absolutely, firm guidelines around honoring the words unless there's additional clarity or, definition needed under those words, because that's what we just approved as a state, as voters.
Bud Scott, New Health Solutions, Oklahoma, to respond to your question about 2 to 3 most important points. Beyond what's already been mentioned, I think it's highly critical that the non-qualifying condition component of State Question 788 is honored. That is a very unique keystone to this program. It's very unique for the other medical programs across the country because it's evolved beyond just the step where you have, say, 5 listed conditions and a very cumbersome process for adding to that condition list. So it allows for a maximum amount of patients to seek relief under this program, and then also creates an incredible market opportunity for the state as well. So I think that issue right there is just absolutely essential that we're able to keep that in play. The other portions of this are obviously figuring out our business licensing.
Any further
I
questions?
yield.
Thank you, Senator. Out of deference to a member who is not in the committee but has been here with us all morning, I'd like to give Representative Dolans, he has texted me he'd like to ask a question, and I'd like to give him that opportunity. Representative Dolans, you are recognized.
Thank you, Mr. Chairman. I appreciate the leniency. I'm here today on behalf of my constituents in District 93 who are concerned about ambitious entrepreneurs from out of state who are wanting to take advantage of this budding industry. I wanted to get your opinions on the residency rule. Do you think it's too strict, and what would you change about if you could?
So Chip Paul, Clemens for Health, we were pretty specific in those rules. We've seen and paid attention to how this has been done in other states, and we wanted to create a situation here in Oklahoma where we did provide an avenue for outside interest, outside investment, and outside expertise. And I think you'll see that we did that by allowing up to 25% investment, in a marijuana commercial entity. How we protect against the really big players coming in is by the very things that we did in the mechanisms in the law. We don't limit licenses. When we begin to limit licenses, then you just ramp up this dollar tier of what it costs to play, of what it costs to be able to get one. And again, who has money in this space? Who's interested in coming in here? Well, absolutely, there are big California growers. There are big Colorado growers. There are people who put a lot of money into yes campaigns that are interested in coming here. So we need to be concerned with that, absolutely. We need to give, this is about us. It's a we the people thing. It's an opportunity for we the people to be entrepreneurs and participate in this business. So we need to guard consumer safety, as we sort of establish those rules, but we absolutely do not need to restrict any Oklahomans really, right or ability to enter this business.
So Representative Dolans, Bud Scott, New Health Solutions, Oklahoma, I'll try to respond to your question about how effectively keeping out-of-state interest from here. The residency requirements spelled out in 788 are tepid at best. We've proposed we actually have a 2-year residency requirement in our legislative proposal. Now, this is a point of contention legally across the industry because states are starting to get rid of their residency requirements because this has not been fully litigated out yet. But we are proposing that we have actually stronger residency restrictions. And again, once again, the reason for us to have to address this through legislation in a special session most likely is because ownership interests are not defined and there's inconsistent terminology in State Question 788 as it applies to those ownerships and whether they're allowed to have out-of-state investment or full-blown Oklahoma residents. We provide extensive language on how that proposal would actually operate. I think this is something we clearly need to address because there's been ways of doing this. I've done this on behalf of clients in other states. There's ways of circumventing residency laws and restrictions. and there's laws that have developed to address those issues. That's what our proposal has, are those addressing laws.
Ron Durbin, Green the Vote. Some outside investment from states that already have a medical program or a recreational program is sort of essential to this market. As we've talked about with banking restrictions and funding restrictions, having people who are already knowledgeable about this industry coming in willing to loan money into the industry and loan their knowledge into the budding industry in the state of Oklahoma are key and essential points of 788. That's why I think there was a restriction to 25% and not a complete and total restriction, because we want to allow that. What I think where the issue arises, and Bud kind of talked on this briefly, the way the residency restrictions are set up right now, it's restricted on who owns the company that holds the processing license or the growing license or the dispensary license. If you gave me about 10 minutes, I can set you up a company that can own 100% of their interests and siphon off every bit of the money off of a company that holds a processing license, and they go to a company that's completely held by outside interests from any other state or foreign government or whatever. It's not hard to do the way it's currently structured. There needs to be to tighten it up and achieve the goal of 788, there needs to be some strengthening. But make no mistake, it would not take an intelligent attorney or business person 5 minutes to figure out how to get around this requirement and siphon off every dollar out of the state. It's not that complicated.
Thank you for that question, Representative, my friend from South Oklahoma City. I am going to ask some questions as the chair. I will give you I plan on my questions moving relatively quickly because I have been taking notes, and I'm going to hit some areas that I think we have agreement, but I want to make sure that we understand that. As to the question with physician-owned businesses, it has seemed to me like all three groups kind of focused on whether or not a physician can own a dispensary is the Stark requirements, basically the self-referral problem. If a physician owns a dispensary, they cannot refer to themselves. Just like in every other healthcare, the reason it's not federally legal is because as of now there's no Medicaid money. If you do that in any other physician-based business, you go to prison. So have we kind of circled around that agreement?
Yes, absolutely.
Yes. Awesome, that makes sense, good. As to the zoning issues, it appears to me we kind of circled around the idea that, and make sure I'm saying this correctly, we're okay with zoning requirements being applied. What we are not okay with is maybe the legislature needs an express prohibition to what I think is included in 788. You can't use your zoning requirements to completely take dispensaries out of a city.
Correct.
Can't use them as a sword.
Correct. Right.
Yeah.
Yep.
Is that we hit the, I want to hit a little bit of the money going into the industry because I want to make sure everybody has the same expectations. Is there an expectation that medical marijuana, and I'm warning you ahead of time if you say yes, I'm going to challenge you on some numbers. Is there an expectation that medical marijuana under 788, the way it is drafted now, will be a large boon to, for example, education funding in the state of Oklahoma?
Absolutely not.
Are we all in agreement in that?
I would just again go back to what I said earlier. The boom isn't going to come from the tax revenue, but it's going to come from all the supporting industries that will be creating a boom.
Absolutely, and Mr. Cavanis, I totally agree with that, and I want to make sure, because we had some questions, so we're on the same way, so we're on the same wavelength. I'm not hitting the economic benefit of it, but from the standpoint of where the dollars flow, that at the way it stands now, we don't anticipate, and I think there's agreement there. Then as to the PMP, I guess this is my first question. The PMP, there were some questions about whether or not they should use the PMP because it is a Schedule I drug. You had brought up, Mr. Durbin, an issue I actually agree with you, but I lost the day on the PMP. I thought the PMP should have been done at the pharmaceutical level, not at the physician level, but I lost that issue, and it is done at the physician level. I will tell you, I have some concerns with using the PMP at the pharmacy level for medical marijuana, because we're dealing with privacy issues, and that right now we don't open up at that, even though I think it's how we should have done it. Again, I'm a legislature. When I lose, and I move on. Would it make more sense, instead of using the PMP, to use some other system to track?
Chip Paul, Oklahoman's for Health. Absolutely, yes. And again, the community is concerned about this. The community is concerned about law enforcement accessing these databases or other entities. And I'll give you a great example, and again, I'll make this brief, but Hawaii had someone access their patient database and basically try to take firearms away from medical marijuana cardholders. They lost the challenge, but it was, we don't want law enforcement in that database. I think that's a very important thing to our community. So,
is that kind of uniform?
Yes, Representative Echols, Bud Scott, New Health Solutions. Most of these patient registries in other states and what we've set forth in the proposal, and there's plenty of models for this that are very functional, that have access for physicians, for the regulators, and just to make sure protect the patient safety. But I think a major concern is about federal law enforcement access to this as well, because I think regardless of how our state law enforcement or local law enforcement may consider this issue, it's a very different subject at the federal level.
Okay, I just want to throw it out there before we went too deep down that road. The next issue I want to get, that I'm going to phrase in the form of a question, but in the form of a little bit of a politely pointed question. Most of you guys on that panel are my friends, so some of this is going to be, if you're not my friends, only because we haven't known each other long enough. So no enemies over there, but it's going to be a little pointed. All three of you have said, and I 100% agree, that all three groups, that we need to move towards creating essentially a cannabis commission to be able to do everyone. Everyone has said that. To my knowledge, there is a cannabis commission laid out in New Health Solutions, which I'm assuming you're going to be okay with, so this is not as much for you. But I want to know if you all want one, which I am 100% in agreement with. Is there other options on the table, or what do you want it to look like? Because it's time to drill down. So let's drill down for a second. So that's my question.
Chip Paul, Oklahoman's for Health. Absolutely. I think that, if you look at where the industry goes 2 years from now, and how do they affect change or, get something done, you really don't want them coming here. I mean, you really don't. You want them, and we probably, frankly, don't want them coming to the Department of Health. We want a regulatory commission that can deal with industry issues and move fast. And again, if recreational marijuana happens, how are we going to merge those programs? How are we going to regulate those programs? That's the perfect stuff for a regulatory commission. But I think here's a very important thing. That commission, 100%, has to have representation from our community. It's not going to be, and I don't think we'd be very supportive of a 100% governor-appointed commission. It has to have representation both from the activist community and the cannabis industry. And again, if we build a proper regulatory committee, isn't that what we want? I mean, if you're building a committee to regulate insurance, you're going to have insurers on that committee, correct? So that would be the thing that we would look for proper, setup.
Makes sense.
Ron Durbin, Green the Vote. In what we proposed, and we provided you, in Section 11, we set up a medical cannabis advisory board that's responsible for, taking these issues. I think that a subset of the Department of Health that has the authority to propose things, and that the Department of Health could only consider those things that came from this advisory board, would be an ideal situation. The board that we proposed is made up of patients, advocates, caregivers, both adult age caregivers and caregivers who are taking care of patients who are under the age of 18, and then 4 medical professionals in various areas that we suggested. I think you need to have a wide-ranging and encompassing board that's going to deal with all the issues that we kind of mentioned earlier. There has to be an ability for a regulatory agency to deal with the majority of these issues. These are regulations, not statutes. And if you look at New Health Solutions, the reason why theirs is so long is the majority of it is regulations. They just put it in one form. I think if you carve out all the regulations that should be regulations from theirs, it's about the same length as ours. That's the way this should be done. You regulate the framework through statutes, and then you let the regulatory agency get in there and define the nitpicky things that need to be addressed. And you need a board that kind of widely encompasses and can have advocates on the board and doctors, and everybody can disagree and argue to come up with the best solutions. Compromise, as one of the people mentioned, is the only way that this is going to ever work.
And Representative Echols, thank you, Bud Scott, New Health Solutions, and thank you for the endorsement there, Mr. Durbin. One of the issues with our legislation and the reason we did put everything in here was because we saw the nature, the tight timeline here, and recognizing the issues that the health department has with no enabling authority to actually enact this program. So we tried to put this in statute so we could get this program going as soon as possible. Now, the medical marijuana authority and the structure that we've set forth includes mandatory patient representation, representation from a variety of facets of the industry, and then effectively gubernatorial appointments through the Commissioner of Health, the Commissioner of Agriculture, and the President of the Medical Licensure Board, or a physician that has 5 years' experience and participates in recommendations.
Yeah. So I'm going to recap what I heard, and I told you this part that's going to be pointed, but pointed is friendly, by the way. Do you have something, Mr. Moe?
Yes, Chris Moe, Green the Vote. I just want to, well, you're probably about to point this out. There's a theme here, and it doesn't involve law enforcement. As somebody who went through 3468, and that had a cannabis commission in it, a board of 12, I can't remember if it was 4 or 6, but a great deal of them were different law enforcement, and that's not what needs to happen in this situation.
So thank you for that, Mr. Moe. What I want to point out, what I've heard from the 3 of you as I understand it, and I would actually submit that all 3 of you are not saying something that's in conflict. And what I hear is we want the right advocates on the board. What I hear is what I thought your response would be, which I like. You want to take your advisory committee and turn it into a commission, which is kind of the same thing, which I think is a great idea. You've hit Mr. Paul's perspective. What Mr. Scott has laid out is once we make your advisory committee a commission, who picks them? How are we going to get that thing down? This is just like every other statute we have. The point I want to make in my next few, and there's a reason I did that. That is, by the way, probably the biggest issue we have to deal with. Whatever we do, the creation of that commission, if we could find a way, Mr. Durbin, you said some things that I agree, and I took them as good-natured shots, but I'm going to rib a little bit good-natured right back about the legislature has a tendency to go too far or to do special laws, and I kind of agree with you on some of that. But I hope what you guys just saw is part of the issue and part of the problem we're dealing with right now. You all 3 want the same thing, and frankly, if you could have found a way to talk together beforehand, you probably could have had it, because you're all 3 asking for that. It's difficult for this committee when I go to them and talk to them and say, who, by the way, does want to do the right thing, does want to, it gets late, that's why some of that happens, and I think maybe some committee members can be snippy and everybody, so it's no big deal. But I'm not saying that in any way, and I'm trying to choose my words so carefully that you understand they're said from a friend who believes that there's that opportunity here for us to do this, and I'm going to hit that in a couple other questions, and then I'm going to have an ask of the 3 of you guys at the end. I'm a politician. I'm used to having asks of me. I'm going to make one of you guys. I do, you talked about board-certified physician. I only have 2 other issues, and we can come back to you. You talked a little bit about board-certified physician. I have a couple doctors, Mr. Paul and to Mr. Durbin and to Mr. Scott. I want physicians licensed in the state of Oklahoma, but that don't actually pay to be part of a board to be able to participate in this program. But I don't know how to do it under the language. Help me, or tell me that I'm wrong and that that's not what it should be.
Ron Durbin, Green the Vote. I think you can already do it under the language. It says board certified. The state medical board certifies that they have met the requirements to practice as a doctor in the state of Oklahoma. That's a board that is certified. That is all that is required. Now, whether they're a member of the osteopathic board, of whatever, no, I don't think you have to go that far. It's all a question of how far you want to take it. Don't take it that far. Say they are licensed in the state of Oklahoma to practice as a doctor and a physician, and that's good enough. Or say that they are a doctor that's also licensed to prescribe narcotics. Maybe that's one thing you want to require because they have experience dispensing controlled substances. Not a bad idea, but that's all you have to do.
And to Mr. Durbin's point, I would completely agree with exactly what he just said. So if you're licensed to practice medicine in the state of Oklahoma, that's exactly what we meant.
And Representative Echols, Bud Scott, New Health Solutions, we actually included very specific language on this that came from feedback from several physicians and others in the community that had problems with the board-certified language that was included, so it removes the actual board-certified portion of that, makes more reference to licensed physicians, because board certification, when it's taken in the context of discussing specific medical practices, is usually done by a national board rather than a state licensing entity.
Ron Durbin, Green the Vote. The only thing I would say with regards to going to licensed is you're going to pick up every medical resident. They're licensed as a doctor in the state, so you be careful there.
But Scott, except we specify residents are not under that definition.
Representative Jon Echols, see, you guys can't agree when you talk together. And as the last question I have is kind of the hard one. So we have talked a little bit, and I want each of you to have time to answer this because this is kind of the big one. There's been a lot of talk of limiting licenses. I don't know that anybody is talking about that now on the committee. I can't speak for the committee, but I don't know that anybody is looking to limit that number. There are some issues the committee is dealing with in what is the proper mechanism, if anything, because everything else in healthcare, you have some level of a requirement, whether it's just a demonstration of capital, it's as simple as that, whether it's here's where your money came from, if you want to open a home health, if you want to open a hospice, if you want to open a pharmacy, there is some level that you have to comply with. Is there any level that is appropriate? Is there anything? Should we require people to disclose where their money comes from? Should we require people to disclose that they have enough money to run whatever it is they're asking for? And that's the real hard question that I want everybody to have an opportunity to answer. And if we don't do that, my concern, and I don't know that I'm there that I want to do it yet, but my concern with all of that is it would then be the only thing in healthcare that we don't. So what are the possible problems there? And I'll leave that open to again, I saved my hardest question for last, so I'll leave it open to everybody.
Isaac Cabnis with Green the Vote. From my perspective, I would fall more on the side of liberty, and just because we do it in one area doesn't mean that's the right thing to do and that we should continue to do it. I understand that there is a thought process of trying to make sure that people are going into the business who can actually afford to go into the business. I was raised in America where we can dream big and we can make that happen, and by preemptively putting income limitations, funding limitations, stuff of that sort, that's taken that dream away from the little guy, and that's where I've been my whole life. Is I've been a little guy, and that's who I represent. And these types of means tests, although can be protective to the little guy because you're trying to say, no, you don't have enough money, you shouldn't be doing this. Well, that little guy might surprise you. He might be the guy that can take a couple of $1,000s and turn it into a couple of $1 million. That's not our place to stop him. Don't stop me.
Ron Durbin, if I could add, one thing to it, I would urge you to go look at the application that the ABLE Commission has, and actually read through everything that is required on that application, financial disclosures, The questions that they ask, we have created a system in that regard that is so overbearing and almost impossible to get through with the number of agencies you have to go through to report this to the tax commission, the ABLE commission, the state health department, county health department, the city for permits. We have created such a regulatory scheme and required so much information that nobody ever uses. It's created a pointless system that is impossible almost to get through. And the businesses that are in it have figured out how to get through it, but it's an arduous task. What we don't want to do here is to create a system where there's capital requirements and the ingenuity and entrepreneurial spirit of an Oklahoman is fettered because they don't have the same kind of capital requirements. Because once you start requiring that disclosure of capital into their business, then what you invite is regulations to restrict people who have too little. There's no reason to do that. If they don't have enough money, their business is going to fail. If they don't have the ingenuity and the work ethic, they will fail. Let them fail because of their own efforts, as opposed to not even giving them the opportunity because you put some capital requirement or some financial disclosure requirement or insurance requirement on them that precludes them from participating in the market.
Chris Moe, Green the Vote. I'd just like to add to that just a little bit with a slightly different twist. I think anybody with the $2,500 and $1 left over to buy a bud ought to be able to go into the business. And let me tell you why. Because if you stop them, a great deal of these people are going to do it anyway, and that's where your black market comes from. So you want to eliminate the black market. I have plenty of ways to do that. One of them, as I've said before, is giving a home grower somewhere to go with their medicine. Another one, as we say, is to make it easy to get a business license. If you fail, you fail. That's America. It's not your job to protect us from failing. It's just your job to keep everybody safe and stay out of the way.
And Representative Echols, Bud Scott, New Health Solutions, Oklahoma. I think this issue was one of the most controversial portions of our initial proposal on this, of having a demonstration of adequate capital to the tune of $25,000 of liquid capital. All of those caps have actually been removed from this proposal. They're specified in sections, they're specified in section 24. However, we're still talking again about a Schedule I narcotic, and we're still talking about medicine. So there does need to be a demonstration of where your funds come from, and this is a well-developed policy that comes from several other states to prevent the proliferation of cartel and illicit funds in this industry. And also it helps to identify the truth and ownership, like we just discussed a moment ago about out-of-state interest having the ability to basically circumvent any laws that would keep them from surpassing that 25% rate. So the only way you do that is through a CPA-attested financial disclosure form.
Liberty. Everybody deserves the right to fail. And as bad as that sounds, again, we set this up for every Oklahoman. We did as a business. And, we talk about all the time, how do we protect the little guy? We talk about that in our trade organization. We talk about that amongst ourselves. So in the industry, I think we'll have some mechanisms to do that. But again, in our minds, we're dealing with a natural product here. It needs to be regulated, but let's have appropriate, liberty is the most important theme here. It's we the people, so.
Well, thank you guys for that answer and the seriousness of you being here today. I'm going to open up if there's any other questions from the committee. Representative Loring.
Thank you, Mr. Chair. One of the things we haven't talked about is somebody that's passing through the state that has a medical marijuana license from another state. Now, I know in 788, we address a temporary license that a person can acquire. As a practical matter, what are the logistics of doing that? I mean, you're not going to issue them at every welcome center.
Isaac Havness, Green the Vote. I was actually pretty surprised when I went back and read 788 that it put that requirement in there. I think if we could go back and fix that, that might be an area that we might consider fixing. If if I could just wave a magic wand and make it happen, I would say that the state of Oklahoma should be able to recognize these out-of-state cards without requiring them to apply for a special temporary card. So, that would be my hope, just like a driver's license, that when you cross state lines, your license would be good for you to travel through that state. But I understand 788 specifically calls for a temporary license to be granted, and I certainly would not oppose that being changed myself, but I'm sure Chip has an opinion on it.
Yeah, so Chip Paul, Clements for Health. When we wrote that legislation, that was in 2016. And in 2016, I believe there was one other state that allowed, they call it I can't say the word, reciprocal licensing, right? So one other state allowed reciprocity. I did it. Yeah. But we wanted to tightly define that. So again, the intent there obviously is if you're a medical patient in Arizona and you come to visit family or whatever in Oklahoma, you should be extended those same, rights by virtue of our program, and that's what we're trying to do. I would agree with Isaac. By now, the medical programs, pretty much around the country, and even California is getting there, are tight enough where we could probably just allow someone else's card, but we were actually trying to prevent, abuse and black market and people making their temporary cards and, coming in that look like other state cards, like they do temporary IDs. So we wanted some registration process, a little bit of formality. So someone's going to have to think ahead about a month and apply and do those things. That was the intent.
Follow-up? For a follow-up?
A slightly different, well, it is a different question. I'm just as concerned about those Oklahomans that don't want to be exposed to marijuana or their family to be, and I talked with Mr. Durbin last week about this. In Oklahoma, we have the smoking, it's Title 21, Section 1247, which prohibits smoking in certain public places. But it only prevents smoking, and it very specifically says tobacco. It does not apply to vaping, and it would not apply to this. Does anybody have any objection? Help me out with this. So can we expand that to cover vaping and cover marijuana? Does anybody have an objection to doing that?
Ron Durbin, Green the Vote. In public areas, absolutely not. Restrict, vaping is, in my personal opinion, I hate walking through a cloud of the vapor that somebody just let out. I think the same thing applies. So anywhere you would restrict somebody smoking in public, restrict vaping in public, because it creates the same kind of situation that we're trying to move against and away from. So we have no problem with that in public places. Chip Paul. Chip Paul, Clements for Health. One of the things so I agree with what Isaac just said. He said, but only in public places. And again, you should have the right to do that in your home or, privacy, right? So we are firm on that. But one of the first things that we did, it's funny, when a group of us went and met with the Department of Health before all the fiasco and everything, one of the first things that we all agreed on is to respect, the Oklahoma state no smoking laws. And absolutely all of us agree with that 100%. And I believe those, and again, I'm not, I don't live in your world every day, but I believe those do extend to vaping. I don't think you can, okay, so we would, again, be supportive of that extending to vaping, but again, that's not, the intent of our law isn't to regulate vape, clearly, but. Ron Durbin, Green the Vote, if I could, real quick. You can. And I can't necessarily say that Green the Vote agrees with this personal opinion. I would restrict I would include public places to be any place that there's public, like, for example, you can have a smoking bar that's not subject to that. I would say that in a public place like that, there shouldn't be any smoking of it or vaping of it. That's a personal opinion. It might not necessarily reflect what Green the Vote thinks, but it seems to make sense and is consistent with the smoking laws, with that one exception that bars can still allow smoking, which to me probably should be addressed too.
For a final follow-up, then I'll get back in the queue.
Thank you. So just to make sure that we're all on the same wavelength, you wouldn't have any objection to changing the non-smoking laws to include marijuana, because they very specifically say only tobacco products, and to include vaping in those places like at a restaurant, movie theater.
No objection from us, absolutely no objection, so we would agree to that.
And Representative Loring, Bud Scott, New Health Solutions, Oklahoma, we've included that language in our proposal.
Thank you, Representative Fetgatter. You are recognized for a question.
Thank you, Mr. Chairman. I'm just curious, can you tell me what the yield is annually for a mature plant?
Well, Ron,
Chris Moe, Green the Vote. How long do you have? If you go to my page, you'll see me, and they call me Uncle Grumpy, by the way. You'll find my page. I'm standing next to a 12-foot plant. That's in California on a legal farm. That plant put off around 11 pounds. Most people in Oklahoma that grow their own are going to grow more like a half ounce, 3/4 of an ounce, maybe an ounce and a half.
For a year?
Per plant. You said per plant.
Yeah, annually.
Well, the plant grows for 16 weeks. So, I mean, are you asking how much could you?
How much does a mature plant produce annually is what I'm asking.
Ron Durbin, Green the Vote, let me clear up one thing real quick.
I'm just trying to
Where the confusion comes in, this is not a marijuana plant is not an orange tree. It doesn't produce a continuous crop.
Right, yeah.
Once you harvest the flower, the plant is dead. Okay, so there's a difference between perennials and annuals. This is not this is not a perennial, this is an annual. Once it's done, it's done.
Yeah, Chris Moe, Green the Vote, let me tell you, it's 4 weeks seed, it's 4 weeks veg, it's roughly 8 weeks flower, and then the plant's cut down. Then you start all over.
Perfect.
And then drying, of course. Drying and curing is after that, but that's the length of the plant life.
Thank you.
You have a follow-up? Representative Rosecrants.
Thank you again for y'all being here. Kind of get this thing out here. Once again, education being my number one issue, just so many questions come to me from that field. And really I want to know, are y'all working with local schools, superintendents? Have they worked with you? That's kind of open to the whole panel.
And Chip Paul, Oklahomans for Health, working with, we haven't really, again, there's levels of detail, I would say, to what we've been able to do, and so that level of detail hasn't been drilled down to yet. We certainly are, would be concerned what they think and all that, but we've been very concerned about getting this right, getting through this process, getting through the Department of Health process, all that. So not yet, from our organization at least. So.
Ron Durbin, Green the Vote. What I can say is, it's not hard to figure out who we are and how to contact us. Google will lead you down that path pretty quick. We've not gotten any calls. The people who have called and said, can you provide some insight, can you provide some advice, can you give us your feedback, we've done that. We were asked to be here, we're here, we were here last week. We've been before the Department of Health as many times as they would allow us to be there and have us there. I think it goes across this entire panel. I think we can clearly say, if somebody needs guidance or assistance, we're not going to turn you away at all. We're here to help.
Absolutely.
And Representative, one of the things that we've really tried to speak with the health department about is serving from the industry's perspective as kind of a public relations liaison and engaging in PSAs. We've already got some stuff in the works right now with some of our videographers on putting together some film pieces that can be published on television, educating people about how cannabis operates, how this program would operate as well.
For follow-up? It's just kind of like Representative Echols' question. I see some similarities amongst all the groups. Do you have any plans to just kind of combine and become like, this is our combined ideas, compromise? Do you guys have any plans of that?
So Chip Paul, Oklahomans for Health, we've always been the big tent here, so anybody's welcome. We work with these guys all the time. We do things, have common functions, we raise money together, we met with the Department of Health together. So we have the majority of the Oklahoma medical marijuana community or marijuana community, we all work together. And again, we'll work with anybody. I mean, if Bud wants to work with us, we'd love to work with Bud, so.
Isaac Cavanis, Green the Vote. I think what you're seeing up here is that there will always be a set of core values that spread across the industry that we can all agree on. There's always going to be other issues that pop up that we don't agree on. So for all of those things that we definitely can agree on, we would be happy to hold hands and say we agree on these things. There may be other things that pop up that we adamantly disagree with each other, and I don't think that you would get any of us to turn a blind eye to something that we don't agree with. So for those things that we can agree with, we are very happy to agree and come together on, but for those things that we don't agree with, we will argue till we're out of breath.
And Representative, thank you for the question, and I'll just echo some of these sentiments that, we put our original draft out for public comment. It was up for over 11 days. We received 200-plus comments on this thing. We've reached out to every organization that's out there, not just with the cannabis organizations, though, but to the chambers of commerce and to the medical community, because we recognize that this is a bigger issue, and we have to reach beyond just the cannabis activists to try to address sound public policy. So we're fully willing to work with everyone, have been this entire time. We've had some good feedback from several different organizations and individuals, and we'll continue to accept that and work with everyone.
Thank you. Leader Kouplen, you are recognized for a question.
Thank you, Mr. Chairman. I think this question's for Mr. Moe. You were very passionate about the individuals getting their cards and being able to raise their own. Being a farmer and starting to get arthritis, I think I may want to start raising some of my own. But I assume 6 plants out here.
It's legal.
I'm wondering, I assume there's different varieties of marijuana?
Yes, there's
different varieties, different seedlings. Do you buy it as a seedling? Do you buy it as a seed? How much is the seed? How much is the yearly cost of an individual to raise the plant? I mean, these things and the marketing, if you say there's no marketing structure, there will be no marketing structure for the individual who raises his own. You're just raising it for your own consumption, correct?
Yes. Chris Moe, Green the Vote. As far as cost, it's pretty much a worldwide market, runs around $10 a seed. You can get those in any legal state, you can get those online, you can get those all over the place. There's not a shortage of getting that. And in that, I want to emphasize something. We're all talking about how we're going to regulate cannabis in Oklahoma. It's already here, so I hope everybody understands it's here in a big way. So we're actually late to the game. But like I say, it's around $10 a seed. Then, just depends on how you want to grow it. The variations are endless as to what you want to do. You can throw it outside and spend no money on it, and you might get a little something. You can put it inside, spend money on a tent and a light and dirt and everything else that you need, and then your electric bill goes up. And you may spend quite a bit of money on it. The variations of what it's going to produce is greater than the number of people in this room by far.
If I could add one thing, on the commercial side of things, an average grower, and I can't remember if it was the state of California that put this out or it was a business organization, but an average size grower in Colorado is spending about $400 to $500 per pound to grow medical cannabis. So in order for them to grow a pound, they're spending $400 to $500. And again, I told you earlier, the average that they're getting on medical cannabis is about $850 a pound. So there's not a whole huge margin there in that aspect. Of course, people are getting more than that for the higher grade, what they call fire varieties. But, that's a term of art in the industry.
Chris Moe, Green the Vote. I would just say that's, well, no, go ahead. I'm sorry. Go ahead.
For a follow-up, Leader Kouplen.
Thank you, Mr. Chairman. Also, how there's a processing that goes on with the plant, correct? So an individual who grows his own, you either have to take it to a processor to get the oil and whatever, or is there an ability for the individual grower to extract the oils through some process on their own?
Chris Moe, Green the Vote. Yes, there is. You can do all that yourself. There is many ways. There's an ice bath, which is a safe way to do it. There's slightly complicated ways to do it. There's mean, we see head shaking, everybody knows here, there's dozens of different ways to do it. The people at home will be able to do most of that. It'll take some learning. I mean, there's a learning curve there. It's not that easy.
And Bud Scott, New Health Solutions, Oklahoma, we've had extensive discussions with folks interested in doing home grow about how they would do home processing. And the only thing that we propose, and it's in our legislation, is a restriction on utilizing hazardous and combustible materials, because one of the most commercially viable ways of doing extract is through extensive CO2, butane, or propane extraction processes. So when that happens, there's potential for explosion, et cetera. You're dealing with a element that you have to, it's regulated, of course, just like you would on the farm. So that's the only thing we're requesting, is that you not be able to use that equipment in a residential setting, because there's been experiences in the past of people blowing up.
And Chip, Paul, Oakland's Rail, just to add to what Bud's saying, there needs to be, a few restrictions on what you can and cannot do at home. People were blowing themselves up, literally, in Colorado, and we don't want that to happen here. The other thing that we did, though, provide for under the law is that if you are a home grower, you don't have to know how to process. You can take your home grow to a processor. You might have to pay them a fee, but they will process that for you and then give it back to you.
Yeah, for a follow-up, Mr. Leader?
Thank you, Mr. Chairman. Why would you limit the individual growing it from not being able to sell their excess to a processor? I mean, is there a reason for that?
Yeah, absolutely, and Chip, Paul, Oklahoman's for Health. The reason for that is lessons learned from other states, honestly, and as much as it might look like we wrote a wide open law, we did put some governors in, and one of the governors, or one of the stops that we did put in, is that very thing. So in Colorado, when they rolled out their original medical program, they allowed for caregivers to be able to grow a certain amount of plants, and it was more than 6, on behalf of the patients, and then they also allowed those caregivers to be able to sell their excess to dispensaries, or patients to sell their excess to dispensaries. So what you had was this whole sideways way to be a grower without having to get licensed or be, properly licensed, and we didn't want to create that here. So we basically, the way that we saw to shut that off is to only allow the caregiver to grow for that patient, and we need to limit probably how many they can grow for, but not allow basically that caregiver to sell outside of that. So they can give it to the patient, that's it. And then I would really support, Chris's suggestion that if there's excess marijuana, and again, this is something the Department of Health struggled with. We had 30 minutes of hazardous waste discussion with them about what you do with excess. But, in a perfect world, you would provide that excess to an LE authority or somewhere, and then they would distribute that back, to the basically indigent community, or, the community that needed it but couldn't afford it. Hospice community is probably the perfect place, but, yeah.
And Leader Bud Scott, New Health Solutions, just to follow up on that, one of the issues you have with when you're providing a product for sale to the public as a form of medicine, that it needs to be subject to the same testing and quality control standards as would be for anywhere else in the process. So I think the lessons we've seen out of other states is that once you enter that stream, it needs to be subject to the same testing protocols.
Further question, for a follow-up, Mr. Leader?
One last one, I promise. Then why, I can understand the caregiver not allowing them to grow a number of plants, because it does lead, you can lead that off into a side business. But the individual, you talk about the individual who grows more than they can consume, that leads more of the temptation to go into the black market, as was mentioned earlier.
Yeah.
Why not allow a market to exist where they can take theirs to a processor, and on the basis of the quality of the plant or whatever the product is, the processor should have the option of buying it if it's quality. If it isn't, he just chunks it.
Yeah,
And it still gives that individual grower an outlet for the excess and would keep it from going into it. Does that not?
Yeah, no, that makes perfect sense. Chip, Paul, Oklahoman's for Health, that makes perfect sense. But again, if you want to consider that, I think we would be supportive of that. I think that's a little bit of a relaxation, in the regulation, the law that we kind of put forth. So I think that everybody would be supportive of that in the community, and I understand what you're saying. We were just trying to close a hole that we saw in the Colorado system in the law with the whole way that they were, basically, it's a sideways way to be a grower, as if you, so that was the intent of what we're trying to do. But I agree with you. If you have a personal grow and you don't use it all, perhaps there needs to be a way to commercialialize that in certain parameters. But again, we were trying to be a little bit, frankly, overly, restrictive there rather than wide open, so, yeah.
Any further answers? Any further questions from the committee?
Well, if I could just follow up on that just a little bit. I appreciate the tenor of the question and the concept, and several of us have actually spoken about the idea of being able to do kind of co-op grows for the home growers. It's just, again, once you get into that stream of commerce, there's testing protocols that would need to be in place, and everyone needs to comply with those.
Isaac Havanus, agreeing the vote. Going along with what Bud said and what you had said, if a home grower was going to introduce his extra, probably to a processor would be the easiest way to get some testing back in on that before it actually hit the shelves. If that dry bud were to go straight to a dispensary to be sold straight to the public, then there might be a worry of that not being tested, where if it did go through a processing facility, it would still be subject to more tests, so that might be some wiggle room there.
Any further questions from the committee? At this time, I want to thank our presenters for coming. I mean, this is a lot of work that you guys have put in, both in the stuff you put in to help 788 pass and the materials you provided to the committee. Having to answer questions for as long as you did is not exactly fun, but I hope you understand, and I think you saw it's from a learning curve. I do want to leave you with this, so you understand what we do as a committee when we get all this different documentation is we go up. I have no fewer than 4 different documents that's created that show us what the differences are between what you presented and what you presented and what you presented. And I'm a lawyer by training also, and when I used to practice law, I used to tell my clients it's always great to settle, because when you go into the courtroom, you no longer have control. You guys have done a ton of work and are coming together a lot. To the extent you come together as a group with those things, Mr. Cavanis, you talked about these. Nobody's asking you to agree, and I know you know that, especially from me. Don't agree to stuff you don't agree to. But to their stuff there is agreement. Guys, that's helpful to us, because we're trying to put it together here. And to the extent any of my questions, or Representative Rosecrants had a great point on that too, if we implied you weren't working together, you have my sincere apologies, because that's not my implication. You guys are working your tail off, and you deserve to be commended. If it makes people in any industry angry that I ask them to work together, I don't care. You'd be shocked how many calls I get from industries ticked off at me because there's a whole slew of them, because they come into my office and I say, all right, everybody work together. This is a new industry in the state of Oklahoma, and unfortunately for you guys, we're going through growing pains on this in front of the whole world, really. Your industry is going through growing pains in front of the whole world, and you guys are being awesome about how you do that. I mean that you are to be commended as to how you work together. Much more established industries, and they get mad when I list their names, so I'm not going to do it publicly. Much more established industries have a much harder time than you guys do coming together, but to the extent you can, I think that will be helpful. And I wanted to tell you a sincere thank you, and understand that all of my questions, I know this committee, are come from a point of gratitude and not with the incredible hard work you've done. And with that, members, we are going to meet. There was some confusion as to when the meeting was today. It will be 9 a.m. every Wednesday, so it will be consistent, so everybody knows. I know there's a lot of people that want to talk to me. I got to meet with my membership, and then I will be in my office for a little bit after this. Kay has asked me to announce office hours, so I'll hang out in my office for a while after this, and thank you so much for coming. And at this time, the meeting is adjourned.